Could we try any past exam papers, you ask? Yes, was that you? Did I hear this in the background? No, we cannot, because the SRA, in its wisdom, does not publish past exam papers. So the only thing we've got to go on are the sample questions from the SRA. If you are regulars in the show, then you probably know that what we do is that we take the opportunity to have a lunch break, and we utilize that lunch break to have a discussion and the presentation of the SRA's sample MCQs. The most effective way to get through the FLK is to actually try the sample questions that the SRA are giving us. Question 30 from the SRA sample of questions. Question 30, so if you want the other 29 questions, go back to the previous recordings from our previous sessions. Question 30 says the following. In March, a buyer entered into a contract for the purchase of a children's nursery because of a fraudulent statement made by the seller in January about the previous year's sales figures. In April, after purchasing the nursery, the buyer employed a builder to carry out extensive building works to the nursery, including demolishing outbuildings and adding an extension. In May, the buyer discovered the fraudulent statement was false and decided he wished to rescind the contract. Could the buyer rescind the contract? Your options are A, no, because the rescission is not available as a remedy for misrepresentation. B, no, because a third party has acquired rights. C, no, because the buyer has affirmed the contract. D, no, because the restitution is impossible. Or E, no, because there is a statutory bar under the Misrepresentation Act of 1967. Okay, so we are talking about something that has gone wrong. We are in the area of fraudulent misrepresentation. So would you like to venture a guess? Which answer do you think is the correct one? Yeah. Do not be afraid, as we said last week. Don't be worried about it. Okay, don't be afraid of telling me what you think. It doesn't really matter. I think it's more important to sort of participate in what's going on. So even if there's a risk that you might get the question wrong, do not worry about it. If you're feeding these questions to ChatGPT as I'm talking about this, I am now averaging 85% correct. Yeah. So ChatGPT could definitely ace SQE1. I'm telling you this. There are very few areas where it makes mistakes. All right. What do we think is the correct answer to question 30? You ready? Drum roll. It is D. The answer is, can the buyer rescind the contract? The answer is no, because the restitution is impossible. Let us think for a second about the whole idea of responses to a misrepresentation. Now, misrepresentation is a contractual problem. To some extent, you can have sort of tort implications of misrepresentation, but most of the time you're going to come across it as a contractual problem. In order to have misrepresentation, we need what? We need a false statement of existing fact that entices the other party to enter into the contract. Now, why this sounds quite stylistic, but there's a reason behind it. So we need the statement to be false, right? If the statement is true, then we've got nothing to complain about. So the statement needs to be false. But why do we need a statement of existing fact? This is to distinguish misrepresentation from a promise. If somebody promises to do something and then they don't do it, then we're talking about a breach of contract. If somebody is giving you the wrong information as to the state of things right now, this is not a promise about the future. This is something that belongs in the domain of misrepresentation. It's something that happens at the beginning that entices you to enter into the contract. So false, statement of fact, inducement. By the way, does the misrepresentation need to be the only reason why you enter into this deal? No, it doesn't. You can have a variety of reasons, but the key reason, the operative reason, the significant reason needs to be the false statement. So false, statement of fact, induces, and then we have the resulting contract. Okay, so if you satisfy all those elements, what can you do in the response? Well, the way in which you respond to a misrepresentation might have to do with the type of misrepresentation. So we broadly have three types of misrepresentation. We have fraudulent ones, where somebody is giving you the wrong information on purpose. We've got negligent, where somebody is giving you the wrong information because they couldn't be bothered to figure out what's going on. And we've got innocent, where somebody is giving you false information, but they genuinely believe that this is correct because they got it from a source that they consider to be authoritative and so on. Now, what difference does it make if you've got one or the other type? Yeah. The difference does not come with a primary remedy, and this links directly to what the question's asking. The primary remedy for misrepresentation is rescission, meaning you get out of the contract. Yeah? So stepping out of it is the key remedy. Whether you can claim damages on top depends on the type of misrepresentation you had. Historically, in the common law, you could get damages in addition to rescission for fraudulent misrepresentation, but less so for negligent, and you couldn't get it for innocent. This changed with the Misrepresentation Act of 1967. So now they make damages available for fraudulent and negligent misrepresentation. However, all of this doesn't really is not really necessary. That level of granularity is not necessary in answering this question, because this question focuses on the rescission. Now, since I said that the primary remedy for misrepresentation is rescission, so walking away from the contract, then why do we have D as the appropriate answer here? Because we seem to have others. There are some conditions to the rescission, meaning that this may be the primary remedy, but it is not always available. It depends on the circumstances of the actual case. For instance, if third-party rights are affected, then you might not be able to do this. If you've started utilizing the contract, or the performance has progressed above a certain point, it's possible that you cannot step away from the contract anymore. And I think this is important here. This is the situation where we're at. The buyer gets the property, not only gets the property, but then begins to do significant work to the property. They've made alterations already. So in April they purchased they had purchased it already in March. In April they started the work. The builders had carried out a significant amount of work. This is where we're at the moment. So stepping out of the contract now would achieve what exactly? It would mean that you give the property back to the seller, but the property has been fundamentally altered because they carried out all this work. So if it was something that required a lesser amount of intervention, then yes, a rescission, like getting out of the contract, would be the appropriate remedy for a misrepresentation. But here things have gone so far that this is no longer possible. Now, let's see why the wrong answers are wrong. A says no because the rescission is not available. Nah, that's clearly wrong, okay? Rescission is the primary remedy for misrepresentation. B says no because the third party has acquired rights. Well, no, we're not talking about the third party here. I mean, the builder is not the third party, okay? So that's factually wrong. C says no because the buyer has affirmed the contract. The buyer has not affirmed the contract because they only found out about the fraudulent statement later on. So it's not like they discovered the fraudulent statement and then they chose to ignore it, and at some future point they thought, oh, hang on, the fundamentals of this business are different from what we were told. No. So there is no evidence that they've affirmed the contract. As we said, D is correct. Restitution is impossible because they've done a great amount of building work. Why is E wrong? It says there is no statutory bar under the Misrepresentation Act. Okay, I mean, this isn't relevant at all. Yeah. So we seem to have a collection of wrong answers and one that gets a little bit closer to what's going on. Remember, as we keep saying, what is the task that you have to do? If you're preparing for SQE1 and you're preparing to answer MCQs effectively, what is your primary goal? You're getting one of these chunky scenario-based questions that have got 5 possible options for you to choose from. You are not looking for the one perfect answer amongst a collection of completely random information. You are going to be given 5 possible answers that look, at least on a glance, they look possible, okay? You have to figure out then which one of those comes closer to what you're being asked. Yeah. So you're not going to find, it's possible that you're not going to find the perfect answer, but you're going to find an answer that is better than the others. So do not restrict yourself into thinking I'm going to have one absolutely correct answer and the rest are going to be garbage. No, you're going to look for a situation where you've got a variety of plausible ones and you're trying to choose the one that is most plausible than the others. That's the task. So here clearly D, even though you might not know the exact detail about how misrepresentation works and all the rest of it, D comes closer to answering the question. Of course, part of what creates this examination complex is the fact that you've got the minimal amount of time to do this. So you've got like a couple of seconds per question, sorry, a couple of minutes per question. So having the task of going through like a sort of chunky scenario and then the reading kind of wordy possible answers at a very short amount of time is what makes this tricky. But that's why we're here. And that's why every time you grab yourself a coffee, you sit down and do an MCQ. And the more you train, the better you get at it, the more you learn how to sort of eliminate the distractors, like the answers that are wrong, and to pick the best correct answer. You try, and then you get better. And then you're going to be part of the 40% that actually passes the exam if they keep to these horrible statistics as the ones that they had in July. All right. Does that make sense to you guys? If this makes sense and you're happy with it, give me the thumbs up or some sort of emoji, and then I know it's time to move on. In the meantime, I'm enjoying my decaf. Yes. Send me like a crying emoji or like something to share in my pain. Why am I drinking decaf? It's only 1 o'clock, okay? Why would I be drinking decaf? There's only one good answer to this. The answer is I ran out of the standard coffee. You see the tragic situation that we're in. I ran out of the normal one and now I have to drink the decaf in the middle of the day. How am I going to stay awake till the end of it? I don't know. Okay, are we ready for our second question? Let's move on. Question 31. Okay, we're moving into issues of employment law and the consequences of the Equalities Act. Now, when I saw this, I thought, whoops, hang on a second. Do I actually have a video that covers the Equalities Act? And after a bit of head scratching, I remembered that in a video that I published recently that talks about EU law, human rights, in there I've got a discussion about the Equalities Act and the obligation it puts on employers. Now, admittedly, since I had difficulty remembering where I've put this, it's probably not super easy for you guys to find. So I'm thinking it might be a good idea for me to do an independent video that talks about the Equalities Act and obligations that are placed on employers in relation to discrimination, equal opportunities, and all the rest of it. So I have made a mental note to add a video in that category because we are a little bit behind in that material. Because what I'm trying to do here, I'm trying to cover the totality of the FLK, FLK1 and FLK2, so you guys can come back to the channel and use it as a resource, either to introduce yourselves to the topics or as a revision when it comes to it. All right, question 31. A disabled employee at a firm of solicitors has requested that the firm buys some computer software for him to use at work. The software enables a person with the employee's disability to use a computer more effectively. The partners in the firm want advice on their obligations under the Equality Act 2010. What must the partners in the firm do to meet their obligations under the Act? Is it A, they must make substantial adjustments to ensure that the disabled employee is not placed at a disadvantage compared to those who are not disabled? Is it B, they must make reasonable adjustments to ensure that the disabled employee is not placed at a substantial disadvantage compared to those who are not disabled? Is it C, they must make adjustments to ensure that the disabled employee is not placed at a significant disadvantage compared to those who are not disabled? Is it D, They must make significant adjustments to ensure that the disabled employee is not placed at a disadvantage compared to those who are not disabled. Or is it E? They must make adjustments to ensure that the disabled employee is not placed at an unreasonable disadvantage compared to those who are not disabled. Now, this, guys, is a horrible question. The reason is not substantial difficulty, even though you need to be familiar with the provisions of the Equalities Act to answer this effectively. And so the trick is all in the wording, is the choice of vocabulary that answers this. The problem is this is very wordy. I mean, the scenario is not very big, but the potential answers are very, very long, which means that you're gonna spend ages. And remember, you got less than 2 minutes per question. You're gonna spend ages trying to read all this and reread and reread to figure out what's the difference between the questions, because the difference is like minute changes in vocabulary. So this is not my favorite question. Not only it's in an area of the law that people might be unfamiliar with, but also the question is so wordy and so dependent on kind of minute differences in the language that I think is going to prove problematic. On the other hand, you don't have to get everything right, but as I said, you're aiming to get the majority right, otherwise you're going to be in trouble. Okay, Teresa here suggesting B. All right. B says they must make reasonable adjustments to ensure that the disabled employee is not placed at a substantial disadvantage compared to those who are not disabled. Yes, I agree. Thank you, Teresa. This is the correct answer. The trick is matching the language of the potential answer with the language in Section 20 of the Equalities Act of 2010. So what is the requirement that is placed in the Equalities Act? It is, in fact, defining the obligations of the employer as making reasonable adjustments, not simply adjustments, but the reasonable adjustments, and making sure that the disabled employee is not placed at a substantial disadvantage. So what we need is these two. We need the reasonable adjustment, and we need the avoidance of a substantial disadvantage. Okay, this explains why the other potential options are wrong. A says they need to make substantial adjustments, blah 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 blah, so that the employee is not placed at a disadvantage. No, they don't need to make substantial adjustments. They need to make reasonable adjustments. Okay, otherwise the burden on the employer would be too high. C says they must make adjustments, blah blah blah. Again, not only it says adjustments, it doesn't say reasonable, but it says to ensure that the disabled employee is not placed at a significant disadvantage. The wording is not significant disadvantage, the wording is substantial disadvantage. D says they must make significant adjustments, again, to make sure that the employee is not placed at a disadvantage. No, it's not significant adjustments, it is reasonable adjustments. And E says they must make adjustments to ensure the disabled employee is not placed at an unreasonable disadvantage. So, like, we're trying to place them at the disadvantage, we just want the disadvantage to be reasonable? No, this is, again, the wrong wording. So, unfortunately, that's it. You will need to know that the wording in Section 20 requires reasonable adjustments on the one hand and the avoidance of a substantial disadvantage on the other, to find the correct combination of words to select the correct question. If you didn't know it, then unfortunately you're simply guessing. I mean, I'm guessing you could discount E because that just sounds weird, but the rest of them, they probably sound like the same as each other if you don't know the wording of the act. Yeah. So not my favorite question, I have to say, but we're not always gonna find the stuff that I like. The stuff that I like. Contract law, I can do all day long. Company law, I can do all day long. And so, business practice and all of that, I'm really good. Some of the other stuff I struggle. Let's see what comes next in line. What would question 32 be about? Okay. All right, question 32. A solicitor in a law firm has received a phone call from the managing director of a private limited company incorporated in the UK, which is a new client. The managing director wants to know why the solicitor's firm is asking for documents to verify the identity of the company's shareholder. The company's shareholder lives in Brazil and owns and holds the entire shareholding of the company. Which of the following responses best explains the advice the solicitor should give to the managing director? Is it A, the solicitor is under an obligation to identify and verify the identity of the company's shareholder because the shareholder lives outside the UK? Is it B, the shareholder is under an obligation to identify and verify the identity because the shareholder lives in Brazil? Is it C, the solicitor is under an obligation to identify and verify because the shareholder owns more than 25% of the shares? D, the solicitor is under an obligation to identify and verify because of the structure of the company and the way the shares are held by the shareholder. E, the solicitor is under an obligation to identify and verify the identity of the shareholder because there's only one shareholder in the company. Okay, what do we think about this one? Actually, guys, come to think of it, I think the question's wrong. I think we might need to have a chat with the SRA about this one. Which possible answer are you leaning towards? Remember that we need to pick only one, and this is where things get tricky. So if you got multiple questions that appear to be correct, how do you pick the most correct one amongst all of those that seem correct? This is where the task becomes impossible, right? And maybe this is where an element of luck comes in. Can I have any suggestions from the crowd that's watching us live? What do you think? And I was about to say I like this because this is business law, right? But having read the possible options, I'm not that sure anymore. I like it. Let me help you out with something. This isn't part of immigration control, right? So it's not the identity of it's not the nationality of the person or the place that they live that matters. Yeah. Because A says because they live outside the UK, B says because they live in Brazil. I don't think Companies House has got any particular issues with Brazil. Yeah. So Caroline is suggesting C. Yes, you're right. Thank you for your suggestion. The problem is, I'm not exactly sure why you're right. I can tell you you're right, but I don't know why the other options are necessarily wrong. So C is right because if you got significant shareholding, then this significant shareholding needs to be notified. So the relevant statute here is the money laundering regulations of 2017. It imposes an obligation on solicitors to conduct customer due diligence and then provide this information to the authorities as required. Now, the actual answer as to why this is the correct one is because that's how the money laundering regulations actually define the obligation. So if you have a significant shareholding that counts more than 25%, then you are obligated to notify to the authorities. You know why I've got a problem? I've got a problem because E is also correct. It says the solicitor is under an obligation to identify and verify the identity of the company's shareholder because there's only one shareholder. But maybe the answer could be that we are not talking about the company's obligations to notify Companies House as to a person of controlling interest. We're talking about the solicitor's obligations specifically. So this is a horrible question. You're going to be thinking, hang on a second, I know that if I've got people of significant control, this is what the shareholders who've got a controlling stake, who've got a significant stake, that's what they're called in the Companies Act. So persons of significant control need to be notified in Companies House. So when you go into the company's details in Companies House, you can see the names and information about the people who've got significant control. But the actual question here is asking you about the solicitor's obligations. The solicitor's obligations here do not come from the Companies Act, they come from the money laundering regulations. So even though C and E look potentially correct, if we're looking for significant control over the company, it is only C that is the most correct one, because this links up to the regulatory obligations that have been placed on solicitors directly. Now, D, to finish this off, D is incorrect because it isn't about the structure. The structure of the company in the abstract is not the problem. The problem is we're talking about people of significant control over a specific percentage. Yeah, but man, I don't know, how do you feel about all this stuff, guys? Because some questions are broad enough to think, okay, I can manage this. I can have like a broad understanding of what's going on. The SQE requires a rather kind of shallow understanding. You don't need to be able to quote the law. You don't need to be able to remember cases. You don't need to remember what the judges have said. You don't need to kind of explain your rationale in detail. So it requires a sort of shallow understanding over the totality of the FLK. And you go through the majority of the questions and you're thinking, that's all right, I got this, I kind of get what's happening. And then you hit a question like this one that goes into a level of detail that really would not be anticipated and kind of pits different parts of the FLK against each other, because this has to do both with knowledge of the solicitor's obligations, both under the solicitor's code of conduct and other regulatory pieces like the money laundering regulations, and then knowledge of substantive business law. I mean, you need to know what the obligations are in relation to Companies House and company registration and notification of information. So this is what we used to call in the law school a combination question that kind of draws knowledge from a couple of areas. Now, not great. And I find this a difficult one, even if you're well familiar with the various independent bits that the question is about. Now, how are you going to approach this problem? So if you've got combination questions, or you got questions that actually seem to go deeper in a level of granularity than the rest of them, how can you ensure that your level of knowledge is up to scratch? Well, what I recommend is that you go through the more detailed lectures that I'm now putting on the website. I'm putting together a new series where I'm covering the FLK specifically, because I thought I'm covering all the topics for the FLK already, but perhaps this is still leaving you too much work to do individually to match what I'm saying in the lecture against the SRA's specification. So I thought, to make things a little bit easier for you, I'm going to kind of recreate those videos, make sure that they're all up to date and so on, but crucially arrange them following the SRA's specification as to what should be in each part of the FLK. So I'm putting these videos, they're starting to kind of roll out. I currently got tort, contract. I'm doing dispute resolution at the moment as we speak. And I've got legal systems, I think. I don't quite remember now. But I've got like already like 3 of these videos published, and 1 is in preparation. These videos are initially available to channel members. So these are we have some of the people in the room. So thank you guys so much. Paid channel members, for the ridiculously cheap price of less than the price of a latte of $2.99 per month, you can become channel members and access all these videos straight away. And also I do the occasional kind of members only hangout where we talk about stuff. Now, if you don't want to do that and you don't want to spend the $2.99 once a month, is not a big problem. All these videos are on a schedule and they will become available to everybody for free eventually. But if you want to accelerate your process and kind of support my coffee drinking, because as I said, I mean, I ran out of proper coffee and I have to drink the decaf. So if you need to save me from this horror, you can become paid members of the channel. Yes. And I mean, and YouTube gives us additional ways to contribute. You can either send me a super chat. If you hit next to the chat, there's something that looks like a $sign. If you hit that, then you can send money straight away. You can think, this poor man he could run out of proper coffee and he can buy some more. I'm gonna send him a super chat so he goes to Starbucks. But okay, enough with that. I'm changing to the next question. I want to move away from the solicitor's obligation stuff because it got me depressed. I'll tell you that. Okay, question 33. This is the SRA's sample of questions for FLK1. We're working our way through it sequentially. If you want to see the ones that came before, from number 1 onwards, look at the replays of the other live streams that I've got. If you're wondering what's coming next, come back next Wednesday and we're going to do the rest. Now, question 33. A man engaged an estate agent to sell his property. The terms of their agreement were contained in a written document. The agreement provided for payment of commission to the estate agent on completion of a sale, provided that the estate agent introduced the purchaser. The sale of the property completed and a dispute arose as to whether the estate agent had introduced the purchaser. The estate agent brought proceedings against the man for payment of the commission alleged due. Proceedings against the man for payment of the commission alleged due under the agreement. The proceedings were successful at trial, resulting in an award of damages to the estate agent of £12,000. What, if any, order for costs might be expected in the circumstances of the case? Oh, do you guys know anything about this? I'm beginning to know more things about this than I wish for, because I recently prepared like an update for next year on dispute resolution, and I was trying to explain the kind of fixed recoverable costs and all of that stuff. Now, as I told you, I'm putting the new video that kind of maps against the FLK on dispute resolution, so I'm looking at that stuff again. I don't know about you guys, but I'm not a litigator, and I don't aspire to become a litigator, so I find that stuff a little bit heavy going. But unfortunately, it is something that we do need to know. So let's venture a guess. What do you think is the correct answer here? What order of costs should the winner expect? Yeah. So the estate agent won here, so they've got an aspiration of recovering something in terms of their court costs. What do you think they're going to get? Now, don't let the fact that you don't like estate agents cloud your judgment. It is, even though I had a good one recently, I have not had positive experiences with estate agents throughout my life. There we go. So any guesses, guys? What do we think should be the correct answer here? Is it A, B, C, D, or E? The correct answer, yes. The correct answer, according to our friends at the SRA and also Teresa, is D. An order in favor of the estate agent for fixed recoverable costs only. Now, what is that about? That is because from the 1st of October 2023, we've got an amendment to the civil procedure rules in part 45 that introduces a lengthy discussion on what are fixed recoverable costs. You need to look at the latest videos that I have put on dispute resolution and civil litigation to have a complete breakdown of those. I did discuss them in the original lecture that I had on civil litigation, but we've moved on a little bit since then, so there is more information about fixed recoverable costs in the latest videos. So what does this mean? It means that it is not subject to the assessment of the judge, but we've got now a fixed mechanism for determining what those costs are going to be. So Caroline there suggested E. This would have been the correct answer a few years ago, but this was the position before the introduction of fixed recoverable costs. So E says an order in favor of the estate agent for costs on the standard basis and it's assessed by at the conclusion of trial. This would have been the case before the introduction of the fixed recoverable costs regime. The idea behind this regime is to make it easier for the courts and to offer predictability of outcome for the litigants as regards the costs of the litigation process. Now, why are the other potential answers wrong? The first one says no costs because this is the Consumer Rights Act. What? It's not the Consumer Rights Act, sale of property. Okay, so that's wrong. Second, B says an order in favor of the estate agent confined to reimbursement of court fees because this is a small claim. It's not a small claim. It's not. It's £12,000. Yes. So they got damages of £12,000. Small claims up to 10. C says no order of costs because the claim is a small claim. Again, it's not a small claim. Yeah. So you can have claims of value up to £100,000. And this comes now under the new regime for fixed recoverable costs. Now, there is no therapy for this unless you know the underlying law. Probably you can discount the first one because it just seems bizarre to be talking about the Consumer Rights Act in a property transaction, right? But other than that, if you didn't know the rules, it wouldn't help you. If you knew the rules because you've been working on this or you've got prior knowledge from when you were students historically, again, it might not help you because you might not be aware of the introduction of the fixed recoverable costs regime that came in a couple of years ago, like almost precisely 2 years ago. Yeah. Okay, so I cannot tell you that this is my favorite question again. You see how it kind of ebbs and flows. Some weeks we got like a bunch of questions that look really easy, or in any event, they're all in kind of areas of the law that we might be well familiar with, and everything seems to be going smoothly. And you're thinking, I don't need a prep school. I don't need to do MCQs. I'm great. I just need to watch a couple of videos and then I'm good to go. And then we've got weeks like this one that we got like a stack of questions that either are particularly difficult or they're in niche areas of the law that we don't know what to do about. Now, in order to further protect yourselves and get as much training as you need, if you're not subscribed already, I would like to remind everybody about my newsletter. So we have a newsletter at Glintis. Whoops, I'm trying to type this. .co.uk, right? So if you are not already subscribed to this free newsletter, send an email with the subject matter saying subscribe. You don't need to say anything else. I'll work it out to this email address. And I will add you to my mailing list. And then every Monday, without fail, you're going to have an email in your inbox that has a new, fresh, not the SRA sample, a fresh one. Very fresh, created by me. Multiple choice question. You're going to get the previous week's multiple choice question with explanations on why the correct answer is correct and why the wrong ones are wrong. You're also going to get discount codes and freebies for things that I've discovered that might be useful for the community. And, you know, tips to study material, links to relevant videos on the topic of the question and all of that stuff. So all of this happens for free every Monday to the people who participated in the newsletter. And while we're on the topic, I have finally done it, and I would like it from anybody, including you guys, a round of applause. Give me a round of applause first, and then I'm gonna tell you what I've achieved. Yes, let's go. I'm gonna clap myself here, and I'm gonna tell you what I have achieved, and then I'm gonna tell you why I'm very disappointed about it. I have finally finished my interactive study planner. Ta-da! Because as you have probably seen, I publish a study calendar to help people prepare for the upcoming exams. I publish this kind of static, then a PDF, you can print it out. It's a static calendar that takes the FLK and says, if you're starting August and you're going for the January exam, here's what you need to be studying every week to cover the totality of the FLK. Then I have another one that says, if you're starting in January and you're aiming for the July exam, this is how things spread out. And these are great, and they've been going great. They're sponsored by Revise SQE, who are wonderful people, and they enjoy them as well. So this has been working fantastically. But I wanted to up my game and offer something that is a little bit more interactive. So I thought I would like to generate a digital study guide where you get to select your starting point. Because not everybody starts preparing the last week of August, right? Or the third week of January. It could be that you're starting today and you're going for the July exam, or you started the 1st of September and you were going for the January exam, or whatever. So I have created my own digital study planner, which allows you to put your starting date, select which exam you're going for, select whether you're preparing for FLK1, FLK2, or both, and then it already knows the topics, and it already knows which ones are difficult and which ones are easy, right? So there's a value weighting in those topics. And then with all this in mind, the magical AI machine that is behind it is going to spread the syllabus in the time that you've got available to make sure that you cover the totality of the FLK as you're preparing for your examination. Actually, I should give you guys a direct link to the study planner. And just check that this is the correct one. Yes, it is. So this is the gateway for the study planner. And the beautiful thing is, you don't need to sign in. You don't need to give any personal data. You don't need to give any information. You don't need to do anything at all. Nothing. You just put your dates and booyah. And then you can just kind of download the planner or copy paste it into something, and you do what you want. Now, when I've got a little bit more time, and I'm going to put the functionality that you can have something that integrates straight into your Google Calendar, so it goes straight into your calendar. But for the time being, the version 1 of this allows you to just copy paste the calendar or to download it and print it out. And why this sounds great? Why am I disappointed? Because I coded all this myself, and I'm not a coder. So I got my friendly AI agent in ChatGPT to help me along with it, and we coded it together with the AI, arms in hand with the robot. And I was so pleased with myself that I managed to make this work. And then I told some others in a learning and teaching mailing list that I am. I told the others, "Woo! I managed to make my study planner. I'm so happy. ChatGPT helped me. ChatGPT was awesome," and they all shackled me. Because they were all like, you shouldn't use AI. You should do it, with like carved on a stone tablet first and whatever, So even though these guys are about technology, yes, I think they mean technology as it was in 1999. So they were not happy that I used AI to make my planner. So if there are any coders amongst you watching this, you probably think, this man should learn how to code and not use AI. But if the rest of you are lawyers or aspiring lawyers, you know that we cannot code or write numbers or anything at all. Okay, so if ChatGPT can help me do it, then I'm happy. So I would love your feedback. Not on my use and relationship with ChatGPT. I would like your feedback as to whether you actually like the app. So if you get the opportunity, go in there and try it out, and then let me know what you think. Yes. And if this is successful, then I'll make some more. So then the community can have its own free, personalized SQE study planner. Right. That was fun. Let's progress with our question. So we said the correct answer here is D, an order in favor of the estate agent for fixed recoverable costs only is what we're going for. Okay, next question. Next question is question 34. Okay. A company buys drums of an industrial cleaning acid from a woman. Okay. Kind of sounds like they met somebody on the street and bought kind of buckets of acid. Anyway, I don't know. You can laugh at them. I'm not the one who writes the questions, okay? So they buy industrial cleaning acid from a woman and store them in their factory. The drums are not suitable for the storage of the acid, and the acid leaks, causing damage to the floor of the factory. A company employee sees the damage to the floor is being caused by the leak, but fails to move the drums. I'm guessing they must have thought, oh, this is leaking. Okay, whatever. The drums could have been moved at no cost to the company. The company now claims £5,000, which is the cost of the repair to the floor. The woman who sold them the acid refuses to pay the amount, arguing that damages payable should be lower. Will the woman succeed in her claim? Now, this, ladies and gentlemen, is a breach of contract problem. Now, this is a business-to-business contract. Why? Because people don't normally sell vats of acid retail, okay? This has all the trappings of a business to business deal. It's for an industrial process and all of that stuff, okay? So business to business contract, sale of goods contract. Is it a problem that the acid is not stored in suitable containers and it leaks? We do not know what the terms and conditions of the contract are. We were not present for any negotiation between the seller and the buyer. On the other hand, we do know that the Sale of Goods Act 1979 implies certain terms and conditions into contracts of sale. One of these conditions in section 14 is that the goods need to be of adequate quality. They need to be fit for the purpose for which they're supplied for. So if you buy buckets of acid and the buckets are not sufficient to hold the acid and it leaks and damages your floor, then yep, that would be a breach of an implied term under the Sale of Goods Act. And what happens after a breach of contract that causes harm? The victim of the breach has the opportunity to claim compensation. This compensation usually comes in the form of damages. How do we assess those damages? We try and calculate how much money it costs to repair the problem. This would be, the appropriate measure in this case. It would be the cost of cure. We didn't bargain for a messed up floor. How much does it take to fix it? So far, so good. A business-to-business contract. The contract has been breached due to a breach of the implied terms. The way to respond to the breach of contract is an assessment of damages. Now, how much? The woman says less than £5,000. Will the woman succeed in her argument? Your options are yes, because the company is under a duty to minimize its losses by moving the drums. B, yes, because the company is guilty of contributory negligence by not moving the drums. C, no, because the woman must compensate the company for all losses flowing from the breach. No, because the woman must compensate the company for all losses that are in the reasonable contemplation of the company. E is yes, because there is a break in the chain of causation. What? Okay. The last one threw me a little bit. We already said that the woman is responsible for this breach of contract, and therefore she's responsible to compensate. We're not arguing with the obligation to compensate. What we're arguing about is the amount. So does the fact that the company could have reduced the damage by moving these barrels matter at all? The answer is that yes, it does matter, because victims of a breach are under an obligation to mitigate their losses. So what we're interested in here is the doctrine of mitigation. It is one of the limiting doctrines that sort of contain the recovery of damages for breach of contract. If you fail to mitigate your losses, it doesn't mean that you don't get anything at all, but it means that you're going to get a lesser amount from the total loss that you have suffered. For instance, if I've booked a taxi to take me to the airport, the taxi does not appear in breach of contract, I need to find alternative means to get to the airport. I get the tube or I get another taxi. If I get like a private helicopter to take me there and it costs like £100,000, then the court is going to say this is not a reasonable response to the problem. This isn't how normal people are trying to address the situation created by the breach. So in that case, I have failed to mitigate my losses. So if I spend £100,000 on the helicopter, then the court's probably just going to refund the cost of the Uber ride that I could have taken instead. So I'm going to have to foot the rest of the bill by myself. So considering that the victim of the breach is under an obligation to mitigate their losses, the correct answer here is A, yes, because will the woman succeed in the argument to reduce the amount? Yes, she will, because the company is under a duty to minimize its losses by moving the drums. Okay, I know they use the term minimize. The appropriate term would be mitigate, but the effect is the same. Why are the rest of them wrong? B is talking about contributory negligence. Negligence is not the problem here. Okay, this is not a tort. If this was a tort, we could be talking about this. If we treat this as a breach of contract claim, which it is, then we don't worry about negligence. The reason why the fault was there to begin with is not really material. And we don't really care why they failed to mitigate their losses. We just care that they didn't. Okay, so B is wrong. It's not the correct area of the law. C says no, because the woman must compensate for all losses. No, because the limiting doctrines, causation, mitigation, and all of that stuff are there to contain things so it doesn't become unfair on the perpetrator. I know that we need to compensate the victim, but we shouldn't ruin the party in breach if they haven't actually done something that deserves that. D says no, because the woman must compensate the company for all losses that are in the reasonable contemplation. This is about the remoteness. The problem here is not remoteness. Remoteness means how far can you take your losses? What sort of consequences that are causally related to the event can be compensated? Because a bunch of stuff could be causally related, however, they will not be compensable if they don't arise naturally out of the breach. Okay, for things that do not arise naturally out of the breach, you only compensate stuff that are within the contemplation of the parties. If you guys remember the case of Hadley and Baxendale, this is the second test in the Hadley and Baxendale case. So D is wrong, because this is about remoteness. Our problem here is not remoteness, it's mitigation. Will the woman succeed in the argument? It says yes, because there's a break in the chain of causation. If there's a break in the chain of causation and then the loss is unrelated to the breach, then they don't get any compensation at all. Yeah? So if they kind of opened holes in the barrels themselves and that's what caused the leak, that would be a break in the chain of causation, but also it would mean that the woman is not responsible at all. So again, this isn't factually what's going on here. So the correct answer here is A. They were under a duty to minimize their losses and they failed to do that. So they will get some compensation, but not to the full extent. Maybe if they had moved the canisters when the leak was discovered, they would only have suffered like £1,000 worth of loss as opposed to the 5,000. Okay, how are we doing so far? Yes, are you guys familiar with damages for breach of contract? I published like a wonderful short video where it's me swimming around in a pool and stuff, talking about Raxley Electronics and the rules for calculating damages for breach of contract and all of that stuff. So, it's me, I'm dressed as a builder, and then I'm swimming around in a pool, and then I'm kind of narrating the thing in front of some escalators. And I thought it was a beautiful video, but nearly nobody has watched it. You guys don't like, I know what's wrong. You don't like my AI stuff, do you? Do you want me to be physically in the pool before you go and watch the video? Get a head start by watching the AI version, and then, maybe I'm going to jump into the pool by myself at some point. Okay, final question for the day is question 35. All right, so question 35. Let's just have a quick look at something. I know that we spend a little bit more time. Maybe we're getting to the end of your lunch break, but then again, why should we stop when we're having fun? Just hang here with me. Pretend your manager is not behind your back, and we can do the final one. 35. A solicitor has been instructed by a client company that is suffering cash flow difficulties. The solicitor has been instructed by the client to advise on its director's duties in respect of monitoring the company's financial position. In the course of discussions, the client mentions that it is considering attempting to improve its financial position by investing in equity securities and asks whether the solicitor can recommend any stockbrokers. Okay. The solicitor's brother is a partner in a firm of stockbrokers which is authorized by the Financial Conduct Authority and which has made substantial returns for the solicitor and other clients. The solicitor has concluded that making the referral would, one, not in any way compromise his independence as the client's legal advisor, and B, be in the best interest of the client because the stockbrokers are great. The solicitor will not get any financial benefit from the referral. The solicitor knows that the brother would be grateful for the business introduction. Which of the following steps should the solicitor take next? A. Cease to act for the client. B. Refer the client to an individual at the stockbrokers other than the solicitor's brother. C. Get written confirmation from the brother that the solicitor will not get the financial benefit in return for this referral. D. Inform the client that the solicitor's brother is a partner of the stockbrokers. And E. Ask somebody in the solicitor's firm to refer the client to the stockbrokers. Okay. What do we think is the correct response here? It obviously has to do with the ethics obligations of solicitors and how do we deal with potential conflicts of interest. In order to be able to answer this, you need to have an appreciation of what is in the solicitor's code of conduct. I've got a short video presenting the code of conduct and the key obligations that you guys can have a look at. But if you are familiar with other areas of the law that are dealing with conflicts of interest and how to resolve those conflicts through disclosure, this is, for instance, what happens in the case of directors' duties when the directors are having conflicts of interest. So the logic is pretty much the same. So what's happening with dealing the problem through disclosure, whether you're a director or a solicitor, the format is similar. So Caroline is suggesting D. Inform the client that the solicitor's brother is a partner of the stockbrokers. Yes, you are correct. This is the correct answer. Now, why is this the correct answer? We are looking at a warning or a prohibition on personal relationships. This is in principles 2 and 7 of the Solicitor's Code of Conduct. When we have a potential conflict that arises out of a personal or a family relationship, then this is dealt with through disclosure. So they need to tell the client that the solicitor's brother is working at the stockbrokers and then let the client make up their own minds. Now, the other solutions are not appropriate. A says, cease to act for the client. This is too extreme. You don't need to do this. You don't need to drop the client. B says, refer the client to an individual at the stockbrokers other than the solicitor's brother. Well, I mean, the problem is not simply personal, is that the firm has an interest, not just the brother. So the connection is there, whether the solicitor's brother himself is dealing with the client or simply the firm of stockbrokers. So referring to another individual is not solving the problem. C says, get written confirmation from the brother that the solicitor will not get a financial benefit. Again, this is irrelevant because the concern wasn't about financial benefits to the solicitor. The concern is because of the nature of the referral, because they're already connected. E is also not appropriate. Ask somebody else in the solicitor's firm to refer the client. So you don't actually solve the problem by saying, yeah, I'm not gonna tell you to go to my brother's stockbroking firm, but you know, if kind of Jimmy here tells you to do it, then it's all the same. It's like, you know, this is obviously an evasion. Okay, it doesn't solve the problem. The only appropriate way that is consistent with the solicitor's code of conduct that you can solve this problem is by disclosure, by informing the client about the personal relationship between these individuals, and then you let the client make up their own mind, which is, you know, perfectly fine. The client could take the decision that this is a great stockbroker and they want to go with them anyway. Question 36. A client objects to a decision which has been made to grant planning permission for the building of a supermarket on land near his home. The client has discovered that the chairman of the planning committee has made the decision, the person who did the decision is a non-executive director of the supermarket chain in question. Which of the following best describes the status of the decision? Is it A, only where the facts suggest to the court that there was in fact a conflict of interest and that the decision was in fact biased, will the decision be held unlawful? Is it B, if the client can prove that a fair-minded and informed observer would naturally conclude that there was a conflict of interest, the decision will be held to be automatically biased and thus unlawful? Is it C, for the decision to breach the rule against bias and thus be held unlawful, the client must prove to the court on a balance of probabilities that the chairman was actually biased? Is it D, only if the facts suggest to the court that the fair-minded and informed observer would conclude that the decision was biased, will the decision be held unlawful? And is it E, if the facts suggest to the court that the fair-minded and informed observer would conclude that there was a real possibility of bias, the decision will be held unlawful? Okay, let's have a think. Which one do we reckon is the correct answer? Feel free to stick your opinion in the chat, or make a suggestion. If you're watching this on the replay, you can still make a suggestion and tell us why you think that's the correct one in the comments. Okay. Now, which one's the correct one? The correct answer to question 36 is E. If the facts suggest to the court that the fair-minded and informed observer would conclude that there was a real possibility of bias, the decision will be held unlawful. Okay, why is that? Why is this? We are thinking about the area of procedural impropriety in the field of judicial review. The specific rule that we're looking at is the rule against bias. Now, why do we care about bias? Because it is a key element of the principle of natural justice, that people who make decisions, they ought to make decisions in an upfront manner on the basis of publicized criteria and not to be swayed by considerations that are not part of this criteria. When somebody is biased, meaning that they've got a preconceived notion as to who should be awarded something or who should win or who should get the service or whatever it is, then they're not making their decision on the basis of the independent criteria. They're making their decisions on some sort of personal preference. So this is not cool. We've got a few cases that offer us legal tests for apparent bias, because this is what we're talking about here. Because you see, the guy who took the decision is a non-executive director of the supermarket chain in question. So there's a link. So there's an apparent bias. A relevant case here would be Porter versus McGill, is a question from 2001. The court said, the question is whether the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility of bias. Right. How do we apply this principle? You don't need to know the names of the cases for the SQE, obviously, but if the law comes from a case, it kind of helps you to kind of remember what's going on and to figure things out if you actually know a little bit about the case law. It's not very often that we mention cases in the context of this activity. But how do we apply this rule to the scenario? The chairman of the planning committee is a non-executive director of the supermarket chain, okay? He approves the application of the supermarket chain. The relationship creates a potential conflict of interest. The issue that we're wondering about is not whether the chairman was actually biased, but whether the appearance of bias would cause an objective observer to doubt impartiality. So we're focusing on a real possibility that the decision would be unlawful due to apparent bias. So that's why E, if the facts suggest to the court that a fair-minded and informed observer would conclude that there was a possibility of bias, the decision will be held unlawful. This is the closest option that we have to the test. Why are the others wrong? The first one is wrong because we don't require actual bias. B is wrong because it talks about automatic bias. We don't require automatic bias. C is wrong because it says proof of actual bias. Again, this is not necessary. And D is wrong because it's missing some wording. We need a real possibility. You just don't. Just saying it's biased is too vague. So we do need a real possibility. So if we take the test from Porter and McGill, the correct test here for figuring whether the decision is lawful or unlawful is whether a fair-minded and informed observer would think that there was a real possibility of bias. Okay. Now, I don't know how you guys feel about this. I find the question a bit difficult. It's because this is an area of the law that I'm less familiar with. Things that have to do with administrative law and the application of judicial review tend to be a little bit niche. If you're a recent law graduate, this might not be something that you've necessarily come across in the context of your studies. I mean, back in the day, we used to do administrative and public law, and we spent some time on it. I think these days people spend a lot less. So if you're a recent graduate, it could be that your knowledge of this is a bit weak, but there are some commonalities with other areas of the law. Because if we're talking about conflicts of interest and how these appear and what is the appropriate response to conflicts of interest, you might be thinking about the business law FLK when we're talking about directors and directors' duties and about conflicts that they get involved in. So the concept of conflict of interest is common and pervasive across the FLK. The particular application to judicial review is perhaps what is new here. Yeah, there we go. That's why we do these questions, to make sure that we've got an understanding of the totality of the FLK. As we've said in the past, what the SQE requires is not a particularly in-depth, but at least a consistent level of understanding across all areas of the FLK. Because they have so many questions that, they input into the exam that they do actually physically have the capacity to ask you a question about every single area of the FLK. So they will spread the questions that they cover pretty much everything. What is required of you is a consistent, albeit shallow, I have to say, but consistent understanding across all areas of the FLK. Now, sometimes you might get a question that you're a little bit more familiar with and you get lucky, sometimes a little bit less and you're unlucky. You don't need to get them all correct. You just need to get, more than half, I would say. The way that they count the scoring now, I think you could pretty much lose 40% of the questions and still scrape enough to pass. But don't quote me on this. The way the pass grades are dropping, I don't know what's going on anymore. Okay, are we ready for our next question? So move on to question 37. All right, here we are. A solicitor is advising a client on an employment contract in respect of a position that the client has been offered in a startup company. The client has a permanent position in an established company. The following day, the solicitor sits next to an acquaintance at a golf club dinner. Not classist at all, right? They could have been eating tea next to each other in the kebab shop, but nope, it's a golf club dinner. The new acquaintance tells the solicitor that he is concerned that the business he works for is bound for financial failure because its key customer is to be taken into receivership shortly. The new acquaintance then tells the solicitor the name of the business he works for. Much to the solicitor's surprise, it is, by coincidence, the startup company. Is the solicitor obligated to inform the client of the reported concerns about the financial prospects of the startup company? Your options are: no, because the information was obtained in the course of the solicitor's personal life and therefore does not impact on his professional obligations. B, no, because the duty of confidentiality overrides the duty of disclosure. C, no, because information obtained from clients must be kept confidential unless disclosure is required or permitted by law or the client consents. D, yes, because the information is material to the client's matter. E, Yes, because the duty of disclosure overrides the duty of confidentiality. Okay. Right. Now, this will remind you of the duties of the solicitors, issues about professional privilege. It might also remind you of issues that have to do with disclosing confidential information that you obtained in the course of employment, where it might have market significant implications. So, this is the field of insider information and insider trading and all of that stuff. So, every time you get in a sort of question which says, I overheard this and this is business significant, you'll be thinking about this. What is your status? Are you the solicitor? Are you the client? In which context is this information changing hands? And secondly, if you're getting the information from an insider in the business, were you to act on this information for private gain or publicize this information so other people act for private gain, would you be breaching rules that have to do with disclosure of financially relevant information? And would you be guilty of insider trading and stuff like that? Now, this particular question is less focused on the insider trading, on the kind of financial implication. It's more focused on the solicitor's obligations. So let's have a think. We've got a few people kind of watching us live right now. Thank you guys for turning up. What would you think is the correct answer? What would you do in this situation? Would you pass on the information to the client? Would you tell them, man, it's a bad idea for you to quit your job and join this startup at this moment because they're not doing very well? Would you be allowed to say this? I know you would be tempted to because you want to do well by your client, but are you technically allowed to say it? Ta-da! The answer is yes, you're allowed to say it because the information is material to the client's matter. We're thinking about the solicitor's duty of confidentiality and their duty of disclosure. Where are we going to find information about those? You should have a look at the SRA's Code of Conduct for Solicitors. In this situation, the man may be a solicitor, but they're not receiving the information in confidence from a client. They're not receiving this information in a professional context. The information was obtained socially, it was obtained informally. There is no duty of confidentiality owed to the acquaintance or to the acquaintance's employer, right? So the fact that the man is a solicitor doesn't really matter, right? Because this communication is not in the context of his work. Because it's not in the context of his work, there is no legal or ethical restriction preventing the solicitor from sharing the information with the client. So the client is about to leave their nice job for something exciting in the startup. They will be making a mistake because the fact pattern says this startup is about to go under because their key client is about to go under. So the solicitor would be doing their client a service by passing on this information. Let's see why the other questions are wrong. A is incorrect. Professional obligations apply whether the information is obtained personally or professionally, okay? So if we're not talking about the context in which you got the info, if you're acting in relation to your professional obligations, the important thing here is that it wasn't professional, okay? It could be that the solicitor obtained something in the context of their personal life, but they could still have obtained it from the client, okay, if they went for dinner with the client. So the A tries to mislead you as to where the problem is coming from. B is also incorrect. There is no confidentiality owed to the acquaintance, okay? So it's not a matter of whether confidentiality overrides disclosure and so on. There's just no relationship with the acquaintance. C is incorrect because it misstates the situation. The information did not come from a client. E is incorrect because it misdescribes the principle. The duty of disclosure does not override confidentiality generally. Here we have a different problem. So the correct answer is D. The information was not obtained in a professional setting. It was not obtained from the client. There is nothing to prevent the solicitor from passing on what would be useful information to their client. Yeah. So keep that in mind. Now, whether if we're treating this as a solicitor obligations and ethics question, we're fine. And this is clearly what the question is about. If the question was about insider trading, then there might be additional considerations to look at. But if that was the gist of the question, then the potential answers would be different from what we've got now. Okay, so don't worry about this. I mean, to be honest with you, I don't think that insider trading, apart from some kind of highlight obligations on the behavior of solicitors, I don't think information, financial disclosure information, the restrictions and stuff are part of the FLK. So this is something that you're going to have to deal with in real life, but less likely to come up as an independent question for the SQE. All right, how are we doing so far? Are we doing all right? We seem to have spent our first 20 minutes here happily, so hopefully you guys are getting value out of this. If you are getting value and if you're enjoying the show, you have the opportunity to join dozens of other friends of yours who have joined the channel as paying members. So for the minuscule amount of less than this coffee, actually, hang on a second. This is an instant coffee. It probably doesn't cost that much. Let's say that I bought this coffee at Starbucks. Yes, you would pay more for a coffee at Starbucks than you would pay for a monthly subscription to this channel. So for $2.99 a month, you can become channel members. What are you going to get as a result? You're going to get, everybody gets these live streams, okay? So no issue there. But you're going to get the occasional office hour live streams for that are special for me and my channel members. And this is the important bit, you're getting to see straight away all the videos that are queued up for release for the next few months. And I've got a lot of great videos coming up. I am doing a new series on the FLK when I'm reworking the material specifically on the SRA's specification, because I thought it might be a little bit tricky for people to follow what's happening as the content of my videos and kind of transpose this against the SRA specification for the FLK. I mean, they were roughly built on the FLK anyway, but I thought it might be useful for people to make this more explicit. So I'm redoing a new set of videos, updated for the exams in 2026, that I'm taking the SRA specification as a table of contents. And I'm actually dealing with every issue in the specification one by one in that correct order. So that way, you guys are getting exactly what you need, and you can use those videos as an introduction to the study of the FLK if you're new to your preparation, or if you're getting closer to the exam, you can use these videos for a revision and be secure in the knowledge that you're only listening to the stuff that are directly applicable and directly relevant to the FLK. So all of these videos are coming out. I'm finishing one now on the English legal system. That has got and they've all got funny visuals that they start with. They've all got a story that they're built around, right? So that's also, I think, a funny thing to watch. So everybody will get those videos eventually, but if you're in a hurry and you want to accelerate your preparation, you can join the channel as paid members and you can see all the videos. Once again, thank you to all the people who have joined us recently and they're supporting this effort. Are we ready for our next question? Let's move on to question 38. Oops, here we go. And by the way, if you guys are enjoying this and you find this valuable, hit the like button. So then YouTube knows as well that you guys are having a good time and doesn't forget to show you the notification next time that our live stream is on, right? So a like and a share always kind of helps YouTube understand that people are having a good time. Right, now, question 38. A man is employed by a roofing company to repair roofs. Great, because if he was employed by a roofing company to kind of wrap kebabs, that would be strange. Now, the role requires him to wear special gloves in order to protect his hands when he handles roof tiles. Whilst standing on some scaffolding negligently erected by the roofing company, he falls off, suffers serious injury to his head, and brings a claim. He carelessly failed to wear the gloves at the time. Which of the following best describes whether the company can successfully claim a roofer? Now, you guys remember what contributory negligence is? It is a concept in tort. And the way this works is that it says If somebody has suffered loss, somebody has been the victim of a tort, then they can have their damages, they can have their compensation reduced if they also contributed to the damage that they suffered due to their own actions. So we acknowledge that a tort has been committed and a person has suffered loss as a result, but if the loss that they suffered has been augmented, has been made worse by their own actions, then that counts as contributory negligence. Therefore, it does not completely absolve the person who is responsible for the tort, but it reduces the amount of money that they can collect as remedies, meaning that they will not be compensated for the totality of the loss that they're suffering. This is what contributory negligence is about. Our possible options. So, which of the following best describes whether the company can successfully claim contributory negligence on the part of the roofer? A. The company cannot claim contributory negligence because the roofer's carelessness did not cause or contribute to the injury. B. The company cannot claim contributory negligence because the roofer did not owe the company a duty of care. C. The company can claim contributory negligence because the roofer's carelessness caused or contributed to his injury. D. The company can claim contributory negligence because the roofer's carelessness materially increased the risk of injury. Or is it E? The company can claim contributory negligence because the roofer owed the company a duty of care. Okay. Now, which one do you think is the correct answer? Now, me personally, I find this a little easier to handle than some of our previous questions, maybe because the law of tort is a little bit more familiar. It's like a first-year subject. In most institutions, it might be something that you've got more direct relation with in the context of your work as well. So I find the FLK tort a little bit easier. I've got quite a few nice videos about it. Of a variety of lengths, in fact. So if you guys want like a quick update to the law of tort, then we've got some options available for you. Right. What is the correct answer here? The correct answer is A. The company cannot claim contributory negligence because the roofer's carelessness did not cause or contribute to the injury. Okay? So, in fact, the roofer did not respect his instructions. He did not wear the protective equipment. However, the protective equipment was for a different aspect of the work. And he suffered an accident by falling off the scaffolding because the scaffolding was not correctly erected. It has nothing to do with whether he was wearing gloves or not. Now, if the company wanted to make the argument that if he had gloves, he would have a better grip, therefore he wouldn't have fallen, that would be something else. But this is not what the fact pattern is about. The fact pattern says very clearly that the gloves were there to protect him from cutting himself when he's handling the tiles, not he is on site moving back and forth or climbing the scaffolding or whatever. Yeah. Now, A is correct. Why are the others incorrect? B says that the company cannot claim contributory negligence because the roofer did not owe the company a duty of care. It's not the company that got injured, it's the roofer, okay? So it's the company that owes the roofer a duty of care, not the other way around. C says the company can claim contributory negligence because the roofer's carelessness caused or contributed to the injury. Well, it didn't, okay? So this is factually wrong. C, the company can claim contributory negligence because the roofer's carelessness caused or contributed to the injury. No. D, the company can claim contributory negligence because the roofer's carelessness materially increased the risk of injury. No, it didn't. Okay, so all these are wrong on the facts. E, the company can claim contributory negligence because the roofer owed the company a duty of care. No, the roofer did not owe the company a duty of care, right? The company that owes the roofer. So apparently, not apparently, it's clear. The appropriate conclusion here is that the company owes the roofer a duty of care. The company breached this duty of care by not erecting the scaffolding as it should have been. This led to injury. Whether the roofer was wearing the gloves or not is unrelated to the circumstances of the injury. Therefore, it cannot constitute contributory negligence. So good news for the roofer. Yeah. Moving on to our next question. How are we doing? How are we doing so far? We're getting more people that are joining to watch us live, which is awesome. Is this like a better time for you guys? Let me know. Let me know in the chat or in the comments under this video, because I thought if I normally schedule these sessions at 1 a.m., I thought it coincides with people's coffee break or lunch break. But if I've got more people joining in at 2 and you would like these sessions to start at 2 p.m., then let me know and I can move them. It doesn't make any difference to me. I'm trying to be live at the time that is most useful for the community. So if you guys prefer 2 o'clock, let me know. Maybe I'm gonna run a poll we should do that on the community tab in the YouTube channel. I'm gonna run a poll as to whether you guys prefer these sessions to be at 1 p.m. or 2 p.m. on a Wednesday, and then we can go with that. Alrighty, so now we have made our way down to question 39. A solicitor acts for a client who is raising finance secured against his home to fund his new business. The solicitor will be providing advice and preparing all the necessary documentation in connection with the mortgage. The client asks the solicitor to explain the key differences between a repayment mortgage and an endowment mortgage. Neither the solicitor nor his firm is authorized by the Financial Conduct Authority to carry on regulated activity. Can the solicitor give the explanation requested about the types of mortgages? The possible answers are A, yes, because such advice is a necessary part of the provision of his legal services. B, yes, because he is subject to the solicitor's financial services rules and therefore falls within an exemption from the Financial Services and Markets Act of 2000. C, yes, because the provision of generic advice is outside the scope of the Financial Services and Markets Act. D, no, because such advice does not fall within an exemption from the Financial Services and Markets Act. E, no, because he is not authorized by the Financial Conduct Authority to give advice in respect of either type of mortgage. Okay. What do we think is the answer here? What's the client actually asking? The client is asking an explanation of the difference between a repayment mortgage and an endowment mortgage. You see, the client is not asking the solicitor to help him choose between one type and the other. He just doesn't know what it is. Yeah. So explaining, what you need to consider is, does explaining something count as giving advice? And if that advice is a regulated activity, then you cannot do it if you're not properly authorized, or not. The correct answer here is C. Yes, the solicitor can provide the information, because the provision of generic advice is outside the scope of the Financial Services and Markets Act of 2000. Under this act, only regulated activities require authorization by the Financial Conduct Authority. Giving advice on regulated mortgage contracts can be a regulated activity, but only if the advice is specific and relates to the merits of entering into a particular regulated mortgage. In the case that we got here, the solicitor is not recommending any particular product. He's not recommending any particular lender, right? The client merely asks for an explanation of the difference between two generic mortgage types, what's repayment, what's endowment. That type of generic explanation or factual information will not be regarded regulated advice under the Financial Services and Markets Act, and it falls outside the scope of Financial Conduct Authority regulation. That's why the other options are wrong. A is incorrect. The advice is connected to the legal work, but this isn't really, you're not allowed to offer financial advice if you're offering legal work, and the financial advice cannot be a sideline because it needs to be separately regulated by the FCA. So A is wrong. B is incorrect as well. the scope rules exemption is for activities incidental. The exemption here. This is not the regulated, field at all. D is incorrect. There is no breach because generic explanations do not fall under the regulation. E is incorrect. FCA authorization is unnecessary. So here is simply explaining what it is. To be honest with you guys, if the rules were so tight that you couldn't even explain the differences of things or explain the nature of the law or the nature of the regulatory regime without needing authorization, then half my videos here would be banned because they would be I don't have regulation from the Financial Conduct Authority. I mean, I've got an entire video that's like a very like 4-hour video that explains opportunities for investment in the UK for foreign investors and what are the sort of legal and regulatory issues that they need to consider when they're investing in the UK. This is just explaining the regulatory regime and is offering generic advice and explanation. It is not something that requires to be authorized. Now, if somebody came to me and said, Dr. Yannis, on the basis of that video, which shares would you recommend I purchase? Then I would be providing investment advice. And that is something that I would need to be registered with the FCA and regulated for, right? So here, the solicitor is just explaining something that the client does not know. They're not offering advice. Therefore, they don't need to be regulated. Okay, right. How are we doing so far? Yes, we passed the halfway point in the hour. So you guys hopefully are still okay. Do you find the ads disruptive? For those of you that don't have YouTube Premium, which I like, but I don't recommend because it's too expensive. Yes. So if our overlords at YouTube are listening to this, your product's too expensive. Now, anything that costs more than Netflix is too expensive. And, we all watch Netflix all day long, or, maybe I do, maybe not everybody. Maybe you guys are too busy preparing for the SQE and you don't have all the time to watch Netflix, but I do. So I just refuse to pay for anything if it's more expensive than Netflix. So I would love to have YouTube Premium all the time. But I think it's too much, so I come in and out. If you have YouTube Premium, you can watch this stuff here without any interruption. If you don't have YouTube Premium, then the live stream is going to cut at some point and display ads. So the question was, do you find the ads annoying? Because I cannot stop them, but I got the concern that when the ads are playing and interrupts people, then people kind of lose interest and kind of move out and do something else. But if an ad starts playing, stay with me. 50 seconds later, you're going to see me coming back on, right? And if you're concerned you missed anything on those 15 seconds of absolute value, you can watch it again on the replay. Right, next question, question 40. This is a public law question. Question 40. The UK government has introduced a parliamentary bill to repeal a UK statute. The government is able to command a majority in the House of Commons, but the bill is opposed in the Lords. The Parliaments Act of 1911 and 1949 are invoked in order to pass the bill into law. What further steps are required for the bill to become law? A. The bill will require approval in the House of Commons and to receive royal assent. B. The bill will require approval in the House of Commons and the House of Lords to receive royal assent. C. The bill will require approval in the House of Commons and a UK referendum. Well, that didn't go well last time. D. The bill will require approval in the House of Commons and the House of Lords and in a UK referendum to receive royal assent. Damn. E. The bill will require approval in the House of Commons, the House of Lords, and in a UK referendum. What? Okay. What do you guys think? How's your knowledge of constitutional law? Administrative, public, constitutional, EU law, and human rights and anti-discrimination legislation are all part of the FLK. Of course, they're not examined at the level of the detail that one you would come across if they were doing like a kind of full-scale law degree. Having said that, I forgot that we hardly teach any of that stuff in the law degree anymore, but stay with me. You require a sort of base understanding of what happens in public, administrative, constitutional, EU, and human rights, right, as part of the FLK. So you do need to know some of this stuff. Okay, what is our answer here? Should it be A, B, C, D, or E? Vote now or vote later in the comments. The correct answer is A. The bill will require approval in the House of Commons and to receive royal assent. Why? Because the Parliaments Act of 2011 and 2049 give the Lords the power to block legislation, but this power is not infinite. So these acts enable certain bills to become law without the consent of the Lords, providing that specific procedural requirements are met. Meaning that if the Commons is dead keen of passing some legislation, then they can do it without needing the assent of the Lords, and the House of Lords can at best delay the decision or send it back for consideration, but they cannot endlessly veto a bill. So here, once the bill goes back to the Commons can follow the specific procedure embodied in those acts to actually pass it and progress it for royal assent without the consent of the Lords. So B is wrong, because the whole point of invoking the Parliaments Act is to bypass approval from the Lords, right? And C, D, and E are wrong, because referenda, thank Christ for that, are not a key feature of British parliamentary democracy. Yes. So yeah, I'm not considering considering how the last one went. You're not gonna find many people on either side of the debate that are particularly keen on a referendum. Okay, what do we have next? Next, we have our last question, which is question 41. Let's see what's happening here. Oh, yeah, I like this one. Yes. A man and a woman who have never met each other are at a swimming pool. Yes, this is not a rom-com. This is an SQE SRA produced question. The man had a lesson from a qualified instructor, but due to the negligence of the instructor, the man struggled in the deep end of the pool and drowned. The woman saw the entire incident, and instead of TikToking it or Instagramming it like a normal person, she developed a traumatic neurosis. That means she went nuts. Can the woman recover damages against the instructor for the traumatic neurosis? Damn. Yes. You see, people are accusing the younger generations of being snowflakes. Maybe I shouldn't joke. Maybe this is a serious matter. I went last weekend to Hampstead Heath, and I was looking at the pools there, and there are kind of some swimming areas, and I was thinking exactly the same. This doesn't look like the sort of swimming experience one would survive. Okay, what are our options? Can the woman recover damages against the instructor? A, yes, because the instructor breached the duty of care he owed to the man, and his negligence caused the woman's loss. B, yes, because the instructor breached the duty of care which he owed to the woman, and his negligence caused her loss. C, yes, because the woman is suffering from a medically recognized condition. D, no, because the instructor did not owe the woman a duty of care. E, no, because the woman's loss is too remote. What do we think is the correct answer here? The correct answer here is D, no, because the instructor did not owe the woman a duty of care. Right. What are we thinking about here? We're thinking psychiatric injury, like nervous shock arising in negligence. But we're not only talking about the primary victim having suffered a mental problem as a result of suffering the tort. We're talking about a bystander, a secondary visit, and a secondary victim, and the circumstances in which secondary victims can recover damages. Now, a person can only recover for psychiatric injury if they suffer a recognized psychiatric illness, meaning not just be upset about it, there needs to be something medical, and the defendant owed them a duty of care to avoid causing such injury. So there are two categories of victims here. One's a primary victim, the one directly involved in the accident, and the second is a secondary victim, witnesses or bystanders who suffer psychiatric injury as a result of that. And the law on secondary victims can be found in specific cases. The best known one is Alcock versus Chief Constable of South Yorkshire Police. It's a case from 1992. For a secondary victim to recover, they must show that they had a close tie of love and affection with the primary victim, proximity in time and space to the incident or its immediate aftermath, and the psychiatric injury was caused by direct perception of the event or its aftermath. It must be reasonably foreseeable that a person of ordinary fortitude would suffer such injury. Okay. Now, let's go through the options. Yes, because the instructor breached the duty of care he owed to the man and his negligence caused the woman's loss. Well, no, because that is talking about the duty owed to the man, not the duty owed to external parties. B says, yes, because the instructor breached the duty of care which he owed to the woman and his negligence caused her loss. He did not owe a duty of care to the woman. The woman is secondary victim. So that's not right either. C, yes, because the woman is suffering a medically recognized condition. Okay, so if she had arthritis, could she argue for that as well? It's not as simple as that, okay? So we need the psychiatric illness and the breach of the duty of care. E is also wrong. The issue is not remoteness here, is the existence of the duty. Now, the correct answer by elimination is D, that the instructor did not owe the woman a duty of care. But you know what? I don't like the question. And maybe we should tell the SRA about this. This is the perfect example of MCQs going off the track and putting you in the difficult position of choosing the best available answer, but it could be that all the answers are slightly wrong. The law as it stands for secondary victims, it requires the obligation to be to the primary victim, not the secondary victim. So the bystander, according to Alcock, for instance, they need to have the close tie, the proximity in time and space, the direct perception, and there needs to be reasonable foreseeability that injury would occur. It's not a requirement from Alcock that the duty of care is owed to the passerby. So, in fact, the SRA is giving us D as the correct answer for question 41, but I think all the possible answers are wrong. We can be unhappy about it. And you can be unhappy with the SRA, not with me, because I'm not the one who wrote the question. Yeah? Could any others be any better? Let's have another look at them. The instructor breached the duty care of, well, could we argue that A is a better option here? The instructor breached the duty of care to the man, and his negligence caused the woman's loss. It's a few steps removed from a complete answer, but to be honest with you guys, I think it comes closer as a correct answer than the one that is indicated by the SRA, which is option D. So perhaps we can come back to this and kind of debate it in the future again, but this is something that you need to be prepared for. People are writing these questions. They don't always do a perfect job. So it could be that there's something in the scenario that doesn't make sense. It could be that there's something in the possible answers that doesn't make sense. It could be that more than one of the possible answers seems correct, and then you have a difficult task of sort of guessing which one of the kind of slightly correct answers is the one to choose. Or you could be in a situation like this one where none of them actually seem to match precisely what's going on, or they all seem to be a little bit off, and you need to select the one that is less off than the others. I cannot argue with this. I think I would have gone for A because of the rules as they stand to bystanders. She wouldn't win though, because you see that's what the problem is, because it says yes. She's not gonna recover damages because she doesn't have a close tie of love and affection. So you don't. The criteria aren't that you watch a traumatizing event and then you need to have actually a link to the people in the traumatizing event, and this is what's missing here. So I don't know what to tell you, but you need to be prepared for this to happen to you. When this happens to you, what do you do? There's a solution. Do not linger. Just pick one and move on. Remember that you don't have the time to spend ages thinking about a question or to kind of high-fiving yourself that you caught a question with a mistake and then you can tell the examiners how they suck. You do not have the time to do this. So when you find a question that is ambiguous like this one, or you find a question where all the potential answers appear to be wrong somehow, you still have to make a choice. So then the task becomes quickly make a choice, note it, move on, focus on the other questions. And then it is a bit of matter of luck, perhaps, whether you kind of hit the correct one that the SRA thought is the correct one or not, but at least you haven't lost time. And I think that's an important thing to remember. This isn't real life. Actually, this is very much real life, especially if you've paid the fee. That's what I mean. The questions are not real life. So these are not the real scenarios that one has to address in the context of their work. They're artificial, they're generated. And as generated artificial scenarios, they might carry mistakes. And we need to be prepared for this. Our task is to shift through all those questions in less than 2 minutes per question. So don't get a potentially wrong question or wrong potential set of answers derail you and lose you time. Because in the 5 minutes that you're going to spend trying to work this out, you've lost the time that you have devoted to other questions. And if you run out of time without answering questions, then you've lost a lot more than attempting, even guessing, and moving on. Question 42. A large public limited company leases a vending machine to a small village school. The school has failed to make a payment of £300 due under the lease agreement for the machine. The company has commenced a claim against the school in the county court. The school is defending the claim on the basis that the sums are not due because the vending machine no longer works. The company has instructed its solicitor to compile a list of documents containing, what's this, 267 pages of emails, and to seek expert evidence on vending machines from 2 different experts. Are these instructions likely to be consistent with the overriding objective of the civil procedure rules? Okay, so the question is about civil procedure and the civil procedure rules. What are our potential answers? So, are these instructions likely to be consistent with the overriding objective? No, because the overriding objective requires the parties to help the court deal with cases justly and at proportionate cost. B, no, because the overriding objective requires the parties to help the court deal with cases quickly. C, yes, because the overriding objective applies only to the courts, not the parties. D, yes, because the overriding objective requires proportionality only in regards to the relative merit of the claim, not in regards to the relative value of the claim. E, yes, because the overriding objective applies only to pre-action contact. Okay, would you like to venture a guess as to which one is the correct answer? I know which one I'm voting for. What do you guys think? Do we all remember what is the overriding objective? Yeah. It is, now, if you guys have not revised the civil procedure part, which is inevitably and unfortunately part of the FLK, the civil procedure rules determine what happens in the process of litigation in the courts, and the overriding objective is a sort of background expectation that informs everything that happens in civil procedure. And the aim of the overriding objective is that the justice system achieves just results when it's looking at cases in the most efficient way possible, both in terms of time and in terms of cost. This change was introduced in the new version of the civil procedure rules because of dissatisfaction about increasing costs and delays and dysfunctions within the legal system. And the reason why there were so many costs and delays and dysfunctions is because under the previous understanding of the rules, the parties were in charge of a lot of evidentiary procedures and a lot of evidentiary production processes. Now, clearly, you don't want that, because if you've got a party that is well resourced, they can actually use that to put pressure on the other party by asking multiplicities of opinions from expert witnesses, by asking for very extended disclosure of information and all of that stuff. So the aim of the court is to achieve just outcomes, but in an efficient manner, so that parties who have got differential funds to spend in the litigation don't actually attain an advantage by having more money to spend. So with this in mind, the correct answer here is A. Are these instructions likely to be consistent with the overriding objective of the civil procedure rules? The answer is no, because the overriding objective requires the parties to help the court deal with cases justly and at proportionate cost. Now, this cost would not be proportionate. This is a claim for breach of contract, right? They haven't paid £300 that were due under the lease. Now, seriously, instructing two expert witnesses and spending the solicitor's time to collate documents that contain 267 pages of emails is going to run you bills in the tens of thousands of pounds. Now, surely this is not something that is the time and the money investment suitable to a claim for £300. That's why the correct answer is A. What about the rest of them? The second one says no, because the overriding objective requires the parties to help the court deal with cases quickly. Not only. It's not about speed without context. It's about speed and cost efficiency at the same time in achieving a just outcome. So B is wrong because it doesn't take the totality of the overriding objective in mind. C says yes, because the overriding objective applies only to the courts, not the parties. No, this is wrong. The overriding objective applies to the totality of the litigation experience and guides everybody. D says yes, because the overriding objective requires proportionality only in regards to the relative merit of claim. No, it doesn't. Okay, it's about the whole process. And E says yes, because the overriding objective applies only to pre-action contact. No, that is wrong as well. It applies to everything at every stage of the litigation process. There we go. So if you guys want more information on this, I've got a couple of nice videos on the civil litigation process and where I explain the overriding objective and all that stuff. You can find them. Now, incidentally, I'm preparing a whole new series where I've got videos that are tailored precisely to the FLK. Because even though I've got videos on the channel already that cover the totality of FLK1 and FLK2, maybe they're a little bit difficult to navigate because I was going through them thinking about the topic, but not thinking necessarily about the SRA's specification. So I thought I will rework this material, update it for the exam in 2026, but arrange the material precisely in the way that the SRA lays out the requirements for the FLK. So you're finding now new videos. I've got a new playlist that's called Preparing for 2026, and these videos are placed in there. I've got all these new videos that you can map the information that I'm giving you exactly against the SRA specification, which hopefully makes things a lot easier for you guys to access. Now, all these videos, the moment that I have them ready and they're uploaded on the site, they are immediately available to channel members. So if you want to join the channel for the price of less than a coffee, for the price of a Coke actually, of $2.99 a month, you can see all these videos straight away. If you don't want to do this, which is perfectly fine, and you want to wait a little bit, all these videos are on a schedule of publication and are gradually coming available for everybody for free every week. They publish every Saturday. So all these new videos precisely on the SRA specification. Either you become paying members of the channel, and you can see them all immediately, or you just wait for them and you'll see them every Saturday. And I think they will be a good contribution to your preparation, especially if you guys are kind of gearing up your capacity for the examination in 2026. Are we ready to move on to our next question, which is going to be question 43? How are you guys doing so far? Are you... Do not panic. I think the questions we've got for today are a little bit easier than usual, so it should make everybody feel a little bit better. Throw me an emoji that represents your emotional state. Adri there already gave us like a crying emoji, so I'm guessing, you know, that's the emotional state. How about the rest of you? Hit an emoji button there and let me know how you feel. And you can do this. You don't have to do this now. You can do this as well if you're watching this on the replay. Yeah. Okay. Question 43. A debtor owes an unsecured creditor £5,000 due to be repaid today. The debtor tells the creditor that they can only repay £4,000 and asks that the creditor agree to this being in full and final settlement of the whole amount. Fearing that the debtor, who also has other unsecured creditors, is about to be made bankrupt, the creditor agrees. Question: can the creditor enforce the payment of the remaining £1,000? Your options are yes, because the agreement to accept less than the full amount was extracted under duress. B, yes, because the debtor provided no consideration in return for the agreement to accept less than the full amount. C, no, because the creditor has waived entitlement to claim the full amount. D, no, because the creditor obtained a legal benefit in receiving £4,000 rather than nothing. E, no, because the creditor obtained a practical benefit of receiving £4,000 rather than nothing. Okay, now this, ladies and gentlemen, is a question close to my heart, because it deals both with issues about bankruptcy and insolvency and all of that stuff, but crucially, it has to do with concepts of contractual modification and what do we understand consideration to be, especially in the area of part payment of debt. So if you have done an undergraduate law degree, when you were doing contract law, you're very likely to have come across the concept of part payment of debt. So this is precisely what this is on. Now, is it okay to give a lesser amount in full satisfaction of a higher amount? Can then this agreement to modify the deal and pay less, can it be considered an acceptable modification of the contract that extinguishes the other party from any further obligation? If that's the case, you can pay less than the full amount and have it all finished. If this is not okay, they can come after you for the remaining amount. What do you think the answer is? Who would like to venture a guess in the chat? Let me know how you feel about it. Because I've got strong feelings about this, and I'm gonna tell you in a moment. Yeah. So the correct answer here is, perhaps surprisingly, B. Can the creditor enforce the payment of the remaining £1,000? Yes, because the debtor provided no consideration in return for the agreement to accept less than the full amount. Let me explain what's going on here. Consideration is the concept of value that supports a contract. Both parties are promising to do something that is valuable for the other. Each party promises to do something that's valuable for the other. But remember that I'm talking about promises, right? It's not the actual performance of the thing. They don't have to do it there and then. They just have to promise something that the other party considers to be valuable. When you're having a contract for the first time, like, I'll sell you this phone for £100. I'm promising to give you the phone, you're promising to give me the £100. Therefore, we've got consideration on both sides, and the contract is fine in that regard. If after a while you turned around and said, actually, you know what? I don't have £100. I've got £80. Is it okay if we change this contract and I give you £80 for the phone? Here we've got a problem, because now we're discussing a modification of the contract. But in order for this modification of the contract to be supported by a consideration, we need to have again a promise of value that is different from the original promise. And this needs to be on both sides. If I'm still giving you the same phone, but now you're promising a lesser amount of money, you are doing something different, but I'm not. Therefore, the contract is unbalanced and the modification is not valid. If this went to court, the court would say that the modification fails because there is no new consideration. If I changed something at my end as well, and I was like, okay, you know what? Fine. You don't have £100. I'm gonna give you the phone, but I'm gonna keep the memory card because I paid like £20 for the memory card. So if you cannot pay 100, I'm not giving you the memory card. Are you okay with this? Yes. What has happened then? The original deal was phone with a memory card for £100. Yeah. Now the modified agreement is less money, £80, but you're getting something lesser for me. You're getting something different for me. You're getting the phone without the memory card. So it balances again at a different level. This is what we need in order to find consideration to support the contractual modification. In the scenario that is given to us by the SRA question number 43 here, a lesser amount of money is offered in satisfaction of the full debt. How does this balance? It doesn't, because it's an attempt at a contractual modification, but one party is still expecting the full amount. The other party is promising less. These guys are not getting anything. In order to have this valid and balanced, something different needs to happen on both ends. So this guy might say, oh, I'm going to give you less money, right? Because I cannot afford it. But I'm going to pay you quicker than before. So something has changed here, something has changed here. And the thing balances out again. If the change is only on the one side, then it remains unbalanced. Therefore, it is not supported by a consideration. The modification is not valid. The original obligation persists, so the creditor can enforce the payment of the remaining £1,000. Is there anything else that we could think here that might change the situation? Could we have a discussion of promissory estoppel? You guys remember promissory estoppel? Is the concept that if a promise has been made and the other party has relied on that promise, and it would be unfair in the circumstances to take the promise back, then the contractual obligations are still there, but they cannot be relied on because it would be unfair to the other party. That's how promissory estoppel is meant to work. Can we use promissory estoppel in a situation of part payment of debt? No, we cannot. And we've got a lot of case law backing this up, going back, from like a long time ago up until more recently. You cannot use promissory estoppel in part payment of debt situations. If you could do this, nobody would repay their debts because everybody could use hardship as the reason to say it would be unfair to pay the whole amount. If you're thinking about this, you might think, but wait a second, how can we have settlements then? If you owe money to somebody and you haven't paid, then they probably sell the money to a debt collector. And then the debt collector comes after you and makes you a deal. So how is the deal from the debt collector enforceable while a deal to pay less with the original party wouldn't be? This goes back to what I said originally. Has something else changed? Is it that you're paying less money, but now you're paying in an installment schedule that they proposed? Is it that you're paying less money, but you're paying quicker? Is it that you're paying less money in addition to something else? So long as something has changed on both sides, then it is fine. Or it could be done by deed. You guys know what that is, right? A deed is a formal witnessed document which then means you do not need consideration to make an obligation enforceable. So the reason why we have settlements for money obligations is that either they're made by deed or because you're offered something as part of the settlement that kind of balances the deal on both sides, and there is new consideration to support the new promises. If we stay with the original proposition here, that the only thing that changes is the part payment of debt by the debtor, then this, in traditional contract law technical terms, would not be enforceable and would fail. So the correct answer here, can the creditor enforce the payment of the remaining £1,000? Yes, they can, because the debtor provided no consideration in return for the agreement to accept less than the full amount. Why are the remaining questions wrong? The first one says, yes, because the agreement to accept less than the full amount was extracted under duress. We have no evidence of this in the case scenario. This might be true, but this isn't what's going on here because the question doesn't tell us this. C says, no, because the creditor has waived entitlement to claim the full amount. There is no indication that I have actually waived entitlement to the full amount. So this is factually not supported by what the question says. D says no, because the creditor obtained the legal benefit in receiving 4,000 rather than nothing. No, that doesn't work, okay? Because this would be the case always. And E is wrong for the same reason, because it hints on this idea of practical benefit. You guys remember the idea of practical benefit consideration? If you don't, I've got like a couple of videos explaining the doctrine of consideration. You should go through those and you'll see there in more detail. You'll always receive a practical benefit by having some money rather than nothing. If this was an excuse to validate unilateral decisions to partly pay debts, nobody would pay their debts anymore, right? So, because it's kind of self-evident that it's better to get something rather than run the risk of getting nothing. So, the only correct answer here within the context that the question is set is question B. Now, having said that, I need to remind you guys that this is an artificial exercise. The MCQs that we're attempting for the SQE are structured in a particular way. What we're looking for is not one complete, fantastic, absolute answer, and then the others are going to be totally wrong or irrelevant. What we have is a gradient of potential answers that might go some way towards answering what the question is asking. Your job is not to pick the one super correct one against all the other ones that are garbage. Your job is to pick the one that comes the closest. And for that reason, you need to adjust your expectations. Do not expect to find the one perfect, 100% absolute answer. You are meant to find the one that is the better fit, even though it is not perfect. So if you think about it in that way, it takes away a little bit of the anxiety that you might be suffering by thinking, how can this be the correct answer? It just seems to be incomplete. Because you're not looking for perfection. You're looking for the closest possible fit. So try and remember this. In every question, you're going to be given a scenario that's like another chunky paragraph, and then you're going to have 5 potential answers. Out of those 5 potential answers, one is the one that gets the closest. You're going to have a couple that are close but not quite there, and you're going to have another 2 that kind of are wrong either factually or in terms of the law, right? Your job is to pick the one that comes the closest. Do this quickly, move on to the next one. You got less than 2 minutes per question. You cannot linger, so make a decision, pick the closest match, move to the next one, on you go, right? Hopefully this makes sense for you guys. If you find all that stuff helpful, hit the like button so more people get notified of this of these coffee breaks and they come and join us next time. Yes, because YouTube understands these things by, like, if people comment, if people say something, people hit the like button, then this must be a good experience and they tell everybody else. So if you're finding this a viable experience, hit that like button so we tell everybody else. Okay, now what do we do now? Shall we move on to our next question, which is going to be number 44? Let me see where we're at. Question number 44. All right, good stuff. A driver drives negligently, and as a result of which he has an accident. A passenger in the car is hurt in the accident. The passenger had a serious pre-existing back condition of which the driver is aware. The condition is exacerbated by the accident and the passenger becomes paralyzed. Which of the following statements best describes whether the passenger can claim damages for his paralysis from the driver? Is it A? The passenger can claim damages for his paralysis from the driver because the paralysis was in the contemplation of the parties as possible at the time of the accident. Is it B? The passenger can claim damages for his paralysis from the driver because the driver must take the passenger as he finds him. Is it C? The passenger cannot claim damages for the paralysis because it was not reasonably foreseeable that paralysis would result from the accident. D. The passenger cannot claim damages for his paralysis from the driver because the paralysis did not result from the accident in the normal course of events. Is it E? The passenger cannot claim damages for his paralysis from the driver because the passenger is partially responsible for the paralysis because of his pre-existing condition. Okay, so we are in the domain of the law of tort. I had a nice... I've got a nice updated tort lecture that just came out this Saturday. So you guys can have a look at that one. It starts with a rather shocking take on buying. I'm not going to tell you what, I'm not going to spoil the surprise. I'm not going to tell you what it is. But it starts with a little story of somebody who's ordering a coffee at their favorite coffee shop and something horribly wrong has gone with the coffee. So try and go and watch that video and then tell me how grossed out you are. Okay, so law of tort, we're thinking about causation, we're thinking about remoteness. Normally, to hold somebody responsible for the consequences of a breach of duty of care, the consequences need to be causally related and they need to be, in terms of remoteness, close enough to, or at least legally related to what the breach of the duty was about. So how do we deal with this situation where somebody might be weaker than expected or weaker than the normal person would expect and suffers worse results out of the breach of duty? Now, clearly, we're not debating the commission of the tort here, because if a driver is by law burdened with the duty of care towards passengers of the vehicle and other road users. So if we have a situation where a driver drives negligently and causes an accident, then this is the commission of a tort, and then any injuries that happen to people around or damage to property needs to be compensated as arising from this breach of duty. But should we consider the person's pre-existing weakness as something that breaches causation or something that places this beyond the realm of what should be compensable for this breach of duty? If you got an inclination on what the correct answer might be, now is going to be the time to put it in the chat, because I am about to give you the answer. Okay, you guys are too timid today. What's up? We got a lot of people watching us live, which is absolutely awesome, and thank you guys. But you're not putting your opinions in the chat. We're not gonna judge you, okay? So if you're feeling inhibited, thinking that you're gonna get heckled by the other candidates if you get the wrong answer, don't, okay? So this is your safe place. This isn't the SQE itself, okay? You can make mistakes on kind of guessing what the answer is, and nobody's going to come after you. Yeah. Unless, of course, unless you're actually students of mine who have studied with me, who ought to know all this stuff already. Then I'm going to judge you. But I don't know who you are. So probably not my fault if you get it wrong. Okay. What's the correct answer to question 44? The correct answer, ladies and gentlemen, is B. The passenger can claim damages for his paralysis from the driver because the driver must take the passenger as he finds him. Why? This is known as the egg-shell skull rule. Let me say it again. Egg-shell skull rule. What this means is, if I cannot tap you on the head because you're annoying, and your skull is as thin as the shell of an egg, and it cracks, and you get yourself injured, then it's my fault. I cannot say, oh, I was just being silly, and I just kind of tapped you one, and the fact that this caused serious injury has got nothing to do with me. How should I know that you got a problem in your head? No. Cases like Smith versus Leach Brain from 1962 establish this, that say the perpetrator of the tort takes the victim as they find them. So you're not expected to have known about pre-existing conditions and weaknesses and so on, but it doesn't matter. You cannot absolve yourself of the responsibility because of the particular characteristics of the victim if you're responsible for the breach of the duty of care. Teresa there has put her suggestion as B. Thank you, Teresa. And it is correct. It is in fact B. Why are the other suggestions wrong? A says that the passenger can claim damages because the paralysis was in the contemplation of the parties. This is not necessary, right? This would be the remoteness requirement for breach of contract for losses that do not arise naturally out of the breach. It's a tort case that we're talking about here. The contractual understanding of remoteness is not necessary. C, the passenger cannot claim damages because it was not reasonably foreseeable. Again, same problem. We don't take the contractual understanding of the doctrine of remoteness and apply it to tort situations. D says the passenger cannot claim damages because it did not result from the accident. Right, hang on here. If it did not result from the accident, it would be a breach in the chain of causation. So in that case, yeah, that would be true. If what the accident has been caused by something that is unrelated to the car accident, then you're not going to hold the driver responsible. But this is wrong here because it does not conform with the facts as stated in the scenario. You remember what I told you before? Some questions are going to be wrong because they misstate the law. Some answers are going to be wrong because they misinterpret the facts, right? So in choosing the closest possible answer to what the question is asking, you need to think both about it matching the facts of the problem question that you're given and stating the law correctly. D is wrong because it misrepresents the facts. E says the passenger cannot claim damages because the passenger is partially responsible. This is taking you down the route of contributory negligence. Contributory negligence is through action, is not through characteristics, okay? So you cannot be contributory negligence simply by existing or having a disability or having some sort of weakness or having some particular characteristic. Contributory negligence can only happen if you have committed an action that is negligent, that makes your situation worse. Here, the poor person didn't do anything. They just happened to be more susceptible to the damage than the average person. So, correct answer to this one, ladies and gentlemen, is B. Swiftly, moving on to question 45. Where is that? Question 45. Okay. Now, in 45, A woman owns shares in a private limited company. The shares are not in an ISA. In the 24-25 tax year, the woman receives a dividend of £5,000. Her only other source of income is her salary, and her taxable income, including the dividend, is £41,000. In 24-25, the personal allowance is 12,570, which is with a basic rate tax band between that amount and 50,270. The dividend allowance, thank you very much, government, is only £500. How much income tax, if any, should the woman pay on the dividend? Okay, so we've got a taxation question. I don't know how you guys feel about taxation questions, but they tend to make people feel a little bit uncomfortable because the majority of lawyers are absolutely terrible in counting numbers. I don't know. Give me a distressed emoji if that is you. Because most of the people that I know that get into law, they get into law because they have to count with their fingers, right? That's how they dropped out of all their science classes. But anyway, maybe that's just me. Now, what are our options here in calculating income tax? So, how much income tax, if any, should the woman pay on the dividend? Option A says none, because the dividend was paid by a private limited company whose payment of corporation tax on its distribution of profits satisfies the woman's liability. B, none, because her taxable income, including the dividend, does not exceed the upper threshold for the basic rate tax. C says she should pay income tax at the income tax basic rate for the entire dividend because it exceeds the annual dividend allowance. D says she should pay income tax at the appropriate dividend tax rate on the proportion of the dividend that exceeds her annual dividend allowance. And E says she should pay income tax at the income tax additional rate on the proportion of the dividend that exceeds her annual dividend allowance. Ta-ta-da-da. If you guys haven't experienced this through your own personal tax situation, and if you haven't studied these bits and bobs about income tax and taxation, you are likely to struggle with this one. Yep. So what would you pick as the correct answer here? This is the most difficult question on the set for today, I think simply on account of unfamiliarity with the territory. Yeah. Right. I am going to give you the answer. The correct answer is D. The lady here should pay income tax at the appropriate dividend tax rate on the proportion of the dividend that exceeds her annual dividend allowance. Why? Because dividend income has its own tax rates, and you get a dividend, you get free, tax-free dividend payments, yeah, up to the level specified by the government. This dividend allowance, as it's called, it's given to you by the question, is £500. So if you get £500 paid as dividends from a company in which you own shares, you are not liable for any dividend tax on that one because you're still in the tax-free domain. This does not mean that your overall tax situation doesn't change because you receive this as income, so it's added to all your other income, meaning that your total income has now increased. So it could be that you lose, say, some benefits, or you lose your child benefit, or you lose something else, or it puts you in a higher tax band altogether for your overall income tax because now you've earned more. But so far as the £500 themselves, these are not taxable because they are still within the dividend allowance. I know about this, so I could talk all day, but you don't want me to, okay? It used to be £1,000, now it's 500. I bet they're gonna take it out completely. Now, on the other hand, this is like rich people problems, okay? So there's worse things in the world than paying some tax on your dividend income. But hey, so correct answer is D. What is wrong with the others? A says none because the dividend, blah, blah, blah. This is completely wrong, guys. Completely wrong. This is shockingly wrong because this A confuses personal with corporate taxation and on who gets it. Like the whole thing is garbage. B says none because your taxable income does not exceed the upper threshold. This is also wrong. This doesn't mean anything. This isn't how this works, okay? C says she should pay income tax at the income tax basic rate on the entire dividend. No. Because the rate is not your income tax rate for dividends. They've got their own special rates that are lower than your traditional income tax rates. So that's C. Why is E wrong? Because it says she should pay income tax at the income tax additional rate. Again, this isn't the correct rate for taxing dividends. So all the potential answers other than D are wrong. The thing is to figure out why they're wrong so you prepare yourselves adequately if you're expecting similar questions to come up. Did you find this question difficult, or is this an area of the law that you guys are feeling more comfortable with? I mean, as I said, from my experience in what we're doing with candidates, I don't think people are super comfortable with the tax stuff. So be a little bit wary about this. They have enough questions in the SQE to ask you about everything. So they will inevitably stick some questions in there about unpleasant stuff like inheritance tax and income tax and investment earnings and all of that stuff. They will, okay? So be careful with it. I've got some videos that discuss the basics of taxation, both on a corporate and on a personal level, but I think because we need some more material on this, I'm preparing some new videos for 2026 that are going to go into these areas in a little bit more detail to help you guys out. Are we ready for our last question of the day, which is going to be question 46? Okay, question 46. A solicitor is employed by a firm of solicitors that is regulated by the SRA. Yay! This firm is an exempt professional firm for the purposes of financial services. The firm is not authorized by the FCA. The solicitor is acting for a woman who is considering buying one of two neighboring plots of farmland. The woman would like advice on which of the two plots she should purchase, and the solicitor refers the woman to a chartered surveyor who is linked or tied to a particular land agent. The woman makes her selection and decides to proceed with the purchase of one plot of land on the basis of the advice she receives from the chartered surveyor. Neither the solicitor nor the firm receive a commission or other benefit as a result of referring the woman to the surveyor. The firm and the solicitor comply at all times with the SRA rules and the SRA financial services rules. Which of the following statements best describes why the solicitor is not in breach of the general prohibition under Section 19 of the Financial Services and Markets Act of 2000? Is it A, the plot of land is not a specified investment? Is it B, the solicitor is not acting in the course of business? Is it C, the solicitor can take advantage of the authorized third-party exclusion? Is it D, the solicitor can take advantage of the introducing exclusion? Is it E, the solicitor's advice is exempt as the firm is regulated by the SRA? What do you think the correct answer is? The whole thing here is about the rules of solicitors in relation to ethics and professional conduct. This is not a separate category, but it is examined throughout the FLK. So you might come across questions on ethics and professional conduct, either in FLK1 or FLK2, and they're kind of intermingled with everything else that you study. I mean, clearly, when you're preparing, we do have specific lectures, there are textbooks and stuff like that that discuss ethics and professional conduct, but the way in which they're treated in the examination is by folding them into other areas as you go along. So what would you say is the correct answer here? I am going to give the answer. The answer is A. The plot of land is not a specified investment. It does not fall within the general prohibition of Section 19 of the Financial Services and Markets Act of 2000. Section 19 is saying that one cannot provide advice on specified investments unless specifically authorized by the regulator. If it doesn't fall within specified investment, then this is not the correct tool to regulate that advice. Purchase of property, purchase of land, or purchase of buildings, or anything like this is not one of the specified investments. The coverage of this is various types of financial investments. So as the plot of land is not a specified investment, then the solicitors have got no obligations under Section 19. This is why all the other options are wrong. So whether they're acting, they are acting in the course of business, but whether they can take advantage of specific exclusions is irrelevant because they don't need an exclusion under Section 19 because what they do is not covered. So that's it. Yeah. So you only have one potential correct answer here, which kind of eliminates the need to look at anything else because under Section 19, this plot of land is not a specific investment. This is question 47 from the SRA's sample. A painter goes to a shop which has been trading for several years. He goes there for the first time. The painter hires a set of ladders and signs a collection slip setting out the agreed period and costs. After making payment, and as he leaves the shop, he sees another notice on the shop wall entitled The Notice, which states no liability is accepted for defective products hired. Does the notice form part of the contract between the painter and the shop for the hire of the ladders? Yeah. And I've been in that situation. I have hired a sanding machine and some paint dryers, some wallpaper, strippers and all that stuff from one of those shops. Do not hire a sanding machine without getting the earplugs because you're gonna go deaf. So, maybe a good reason why I can hardly hear anything anymore is spending like a few days with that sander right there. But anyway, the problem of the painter here is slightly different. How can we tell whether terms have been incorporated into a contract? This is traditional contract law area, so that would be FLK contract law. I've got a variety of really nice videos on contract law that cover the totality of the SRA specifications, so you can have a look around the channel and kind of watch those. These are actually some of my most popular videos, and I'm happy because contract law is my favorite area, right? That's what I do. That's what I mostly enjoy doing, right? I do business law, I do company, but the core of contract law, I think, is the funniest thing that one can be involved in. Right. Incorporation of terms. Crucial thing for you guys to remember is that English law does not require formalities for standard contracts. So it is not a requirement that you sign a piece of paper or that you get terms and conditions in writing. It is perfectly possible that you have an oral contract. And then we're talking about any express terms and conditions that have been communicated between the parties. What happens if the parties have said nothing? Do we have any Greek people in the audience or anybody been to Greece? In Greece, we've got these kiosks, right, at the side of the road, like tiny little shops, like they look like a kind of cupboard, kind of surrounded by newspapers and stuff. You can transact in those kiosks with zero oral communication. People, when I was a kid, people just used to go up there, kind of point or kind of nod towards the newspaper that they wanted. The guy inside the kiosk would give them the newspaper. They would give them the money. Everybody would just kind of grunt at each other, and they would go. So did these people have contracts, considering they never said anything? Yes, they absolutely did. In English law, similarly, there are no formalities required for traditional contract formation. What you need is to satisfy a set of criteria. You need agreement that is usually expressed as offer and acceptance. It needs to be supported by consideration, which is an element of value, intention to create legal relations, certainty, and the parties entering into the contract need to have capacity. And that's it. You're done. Okay. You don't see in any of those requirements something that says it needs to be in a document, it needs to be signed, or any of that stuff. It's only specific areas of the law, contracts for the sale of land, insurance contracts, or things along those natures that they need. Okay. So if people don't say much, how do we know that the contract is operational? And how do we fill gaps? There then come the implied terms. Terms can be implied through statute. They can be implied through common dealing between those parties, common dealing within an industry that is consistent enough, or they can come by operation of law in the sense of case law. Right? So that's a little bit of background to kind of dress this up. If we're talking about expressly communicated terms, which is what we've got right now, how do we know that something that has been expressly communicated is or isn't part of the contract? Timing is of the essence. And one of the key requirements is that you get notified in advance of the conclusion of the contract about all the terms and conditions. So let's have another read through the question. Okay, the painter goes to the shop. The shop has been there for a while. The painter hired a set of ladders and signed a collection slip setting out agreed period and costs. When he left the shop, he saw the notice on the shop wall that read "No liability accepted." Is this part or not? I would tell you, if this was a problem question that we were addressing in a classroom together, I would tell you it depends on where the notice was. So he sees the notice as he leaves the shop. What does that mean? Does it mean that the notice is posted at the back of the door, that you can only see it when you're leaving? Or does it mean that the notice was actually somewhere visible within the shop space behind the counter, but he only saw it when he was leaving? That's crucially important. But this isn't a general kind of problem question. This isn't real life. This is a problem question for the SQE as given to us by our friends at the SRA. So we need to understand what the possible correct answer might be within the context of this exercise. Yeah. What are our options here? The question was, does the notice form part of the contract between the painter and the shop for the hire of the ladders? Is it A, no, because the contents of the notice are not incorporated into the contract? B, yes, because the notice constitutes a reasonable notice of its terms? C, yes, because the painter agrees to the terms of the notice by signing the collection slip? D, yes, because having traded for several years, the shop will be able to prove a consistent course of dealing. E, no, because the notice constitutes a mere representation. Okay. Now, this is a bad question. Okay, it's a bad question because it misses the nuance of, it tells me there's a notice that he sees, but it doesn't tell me where the notice is placed in the shop. So I would definitely need more information to be able to resolve this effectively if this was a real case. But this isn't a real case. This is the SQE. You got 2 minutes to work out the correct answer. Let's work by eliminating the wrong ones. If we say E says no because the notice constitutes a mere representation. No, that's wrong. The notice does not constitute mere representation. This is a limitation of liability notice. It depends where it's placed and when it is communicated for us to judge as whether it has become a term of the contract or not. So it is certainly not a mere representation. So E is wrong. So discount that one. D says, yes, because having traded for several years, the shop will have can prove consistent course of dealing. With whom? The shop has been there for years. No problem. I'm not disputing this. But how many times has this painter gone to this shop? A painter goes to a shop. The shop has been trading for several years. It doesn't tell us that the painter is a regular customer. So this could work if the painter had done this business with the shop repeatedly and he knew about this. Or it could work if it is common in the industry to have this limitation of terms and that applies to everybody. I get it, okay? But that's not what's going on here. It doesn't tell us about consistency of practice in the industry. It doesn't tell us that this particular painter is familiar with the shop. So the fact that the shop has been around forever is not relevant and it doesn't answer our question. So E is wrong, D is wrong. C says yes, because the painter agrees to the terms of the notice by signing the collection slip. Yeah, great. But that incorporation by signature will incorporate whatever is in the document that's been signed. And I will agree with you. It could be that they've read the document and they know what's in it. It could be that they haven't read the document and they've got no idea what's in it. Okay, that does not bother us. The important thing is this limitation of liability thing in the signed document? If it is not, then we still have to deal with the problem of incorporation by notice and to reflect on whether this has been incorporated or not. Okay? So C is wrong because this particular term was not in what we were looking for in the signed document. Now, how about B? Yes, because the notice constitutes a reasonable notice of its terms. Again, I cannot answer this very effectively because I don't know where the notice is placed. If I am to choose, so B could potentially be correct, but which one is a little bit better? Is it B, that yeah constitutes reasonable notice, or is it A, that says no, because the contents of the notice are not incorporated into the contract? Okay, this, you're not gonna like this, but I'm gonna say it anyway. This is not an exact science. You are not looking for a definitive answer that is 100% correct. What you're doing is that you're looking for the most plausible answer. It is possible that the most plausible answer is not the sort of optimal answer that we would give in isolation. Okay? So we are going to pick A as the correct answer because the way that this is phrased, it is trying to create the impression that he was not in a position, the painter was not in a position to see this notice before concluding the contract. Yeah? I know that this is subject to debate, and I know that we would spend a lot of time talking about this if this was a problem question that we discussed in class, but we are approaching this in the context of the SQE. So, this is not a great question. It is not drafted very effectively, but it is helping us understand something useful. When you're attempting problem questions in the SQE, you are not looking for perfection. You're always given a scenario, and then you're given a set of options in relation to this scenario. These options are not going to be perfect. It is very likely that out of the 5 options, you're going to have a couple that seem way off. Either they're wrong on the law or they're wrong on the facts. You're going to have a couple that could be potentially okay, but they are also slightly off, and one that looks to be closer. You're not looking for perfect, you're looking for closer. So do remember this. It is a key component of you getting your head around as to what you're supposed to do with the SQE and how you're supposed to approach these questions. You are not looking for perfection. You are looking for closest possible match. And not only that, but you have to do it super quickly, because in the time that you've got allowed for your questions, you got less than 2 minutes per question. Okay? So are we all doing okay so far? We've got another channel member notified, Maria. So thank you very much, Maria, for joining and supporting the channel. It's great to see you live. So yes, so the correct answer is A, because the way it is phrased, it gives the impression that this notification was not visible while people are discussing the rental. It seems that people can only see this notice when they're leaving, which is past the point that they have actually concluded the contract. So what we need for incorporation, we need the notification to be made before the contract is concluded. If the notification of additional terms and conditions comes after the contract is finished, it is too late. Okay? So that's the sort of gist of it. So this was a long way of saying that I don't like the question, but if we interpret the question in this way, it seems that A is the most plausible answer. And in fact, A is the correct answer indicated by the SRA. So let's move on and see if we get a question that is a little bit, I mean, this was not a difficult area of the law, but it was a difficult question to navigate because the question is not drafted in the most appropriate way. So let's move on to the second question, which is question 48. 4 chartered surveyors have set up together in business as a limited liability partnership. 2 of them are designated members and 2 are ordinary members of the LLP. They all work full-time. The members all meet formally once a month to discuss profit and loss, cash flow, and financial forecasts. This financial information has indicated that for the past 12 months, the LLP is not doing very well and it's unable to pay its debts. It has continued to operate, however, and the members have discussed ways of limiting costs. As a result, they've made some considerable reductions in expenditure. At one specific meeting a few months ago, one of the ordinary members suggested that they should obtain financial or legal advice on their position. This suggestion was rejected on the basis that it would make things too expensive. A liquidator is subsequently appointed and to take care of the insolvent winding up of the LLP. The liquidator considers it clear that at the date of that meeting, there was no reasonable prospect that the LLP would avoid insolvent liquidation and is considering whether to bring a claim for wrongful trading against all the members. Which of the following must the ordinary member show to establish a defense against the claim by the liquidator? Now, first of all, a little bit of context here. In insolvency law, the relevant legislation here is the Limited Liability Partnerships Act of 2000 and also the Insolvency Act of 1986. If the people who run the show, be it the directors of a company or the members of a limited liability partnership, if they see that the business is not doing well and there is no realistic prospect that the business will recover, then they are under an obligation to start thinking about the interests of the creditors and wind down the business in a structured way to minimize potential losses for those creditors. What they are not allowed to do is continue to operate as if everything is hunky-dory and ramp up the debts and ramp up the costs and minimize the opportunities for the creditors to actually recover any money at the end of the day. If they do this, if they continue to spend money and enhance the losses without any interest in the position of the creditors, then they might be asked to compensate themselves to the money, to the assets that the company has towards paying its debts. So this is, in a way, an exemption to the rules of limited liability, because if the people in charge are engaged in wrongful trading, then they have to make contributions out of their own personal assets in order to resolve the asset problems of the corporation. So the question here is, by ignoring the sort of dire financial and deteriorating financial position of the LLP, have these members here engaged in wrongful trading? So you are asked to figure out which of the following positions the ordinary member must show to establish a defense against the claim by the liquidator. So is it A, that he took all reasonable measures to reduce expenditure incurred by the LLP? Is it B, that As he is not a designated member, he benefits from limited liability and cannot be required to contribute to the assets of the LLP. Is it C, that he took every step to minimize the potential loss to the LLP's creditors? Is it D, that it was reasonable for the LLP to continue trading in the expectation that the business would recover? Or is it E, that he is not a designated member and he did not have access to all the information necessary to decide whether the business was insolvent? Now, in order for you guys to answer this effectively, you need to be able to distinguish between what is a designated and an ordinary member. Now, in the context of a limited liability partnership, the designated members are the ones who have got the sort of bureaucratic and administrative responsibilities to report stuff back to the authorities, communicate with HMRC, and all the rest of it. Ordinary members are the people who are not tasked with these administrative tasks, but they are still expected to fully participate in the running of the limited liability partnership. So the fact that you're a designated member, it means that you're a point of contact for administrative queries, but it's not the same as saying that you're a director in a corporate structure. So the ordinary members are not the sort of non-executive directors that sit in the background and do nothing. The reality of the matter is that they all continue to be partners and they're all equally responsible for what's happening in the partnership. Therefore, whether you're a designated member or an ordinary member is not going to determine whether you might be liable on a charge of wrongful trading or not. It depends what you have actually done. So if we're trying to pick the correct answer with that in mind, we're trying to pick out somebody who has not engaged in wrongful trading in the way that the provision is actually defined. So the only one that actually does this from our available options here is C. The ordinary member must, to establish a defense against the claim by the liquidator, the ordinary member must show that he took every step to minimize the potential loss to the LLP's creditors. This is option C, okay? Option A is incorrect because it's not just a matter of reducing expenditure. It's a matter of thinking about how the business can survive and thrive in the future and meet creditor demands. B is wrong because it makes a false distinction between designated and ordinary members. E is wrong for the same reason. Now, D says it was reasonable for the LLP to continue trading in the expectation that the business would recover. It's not only that. It's not like without doing anything you think is going to do best. It means what steps did the person actually take to make sure that the creditors' losses would be minimized. The reason for this is that once a company enters in a pathway towards insolvency, then the objective of the management shifts from the interests of the company to the interests of the creditors. Because you might be thinking C, that talks about the creditors, and D, that talks about the LLP, are probably both correct because they're along the same lines of thinking. What you're missing is that the Insolvency Act requires people to shift the mindset towards the interests of the creditors at that point in the company's life, in the company's or the LLP's life cycle. That's why C is the correct answer. Now, I don't know what you guys think. We've got some people watching us live. Would you consider this to be an easy question for you to attempt, or does this go beyond the stuff that the average person would know? I'm so and so with it because I know the insolvency stuff well, and I've been teaching kind of business and company law for a very long time. But I do appreciate that this tends to be a niche area of the law, that unless you're very well involved in corporate structures and corporate decision making and you're concerned about the consequences of corporate failure, these may not necessarily be areas that you have studied in length in the past. I do have some videos specifically on insolvency, the consequences of insolvency, and how one can protect themselves if they think that the counterparties are getting close to an insolvency event. So feel free to go have a look around this channel to look at those videos. But this is very much the standard domain of FLK business law. if you are preparing for this, which you have to, it's not like you have a choice, right? If you're preparing for FLK1 and you're preparing for FLK business law, an understanding of what happens in insolvency, how the incentives of the various parties operating within a corporate structure, what they need to do to prepare and so on, I think it's going to be beneficial. So even though this might come across as a kind of slightly boring area of the law in some cases, I would advise that you guys pay a little bit of attention to this, because it's not really that it's complex, but if you've never heard of it, it becomes a little bit difficult to navigate. So let's move on and see something slightly different. I would like to say thank you to one of our new channel members. We've got, I'm probably going to murder the name here, so apologies for this. We've got Gursimar, who has joined us as a paid channel member. So thank you so much for your support. You can all become paid members of the channel for less than the price of your average coffee. So for $2.99 a month, you can support the channel, and as a result, you get access to all the videos that are queued up to publish. So a new video is coming out every Saturday. For those who are paid members, you can see all of those videos that are waiting in line straight away without having to wait, which can accelerate your preparation. I also do the occasional live streams that are for members only, and there are various other things that members are getting. So if you're going down that pathway, thank you so much, guys, for your support. But our kind of weekly MCQ live streams are going to remain free for the entire community, so we can help as many people as possible. So let's have a look at question 49. To progress a case before the court, the correct interpretation of a section in a statute is required, and the judge considers his options under the rules of statutory interpretation. He decides to use the mischief rule. Which of the following best describes how the judge will use the mischief rule in interpreting the statute? Will he A, consider the defect in common law which caused Parliament to pass the statute? Or B, select an interpretation of the statute which addresses any initial absurdity? Or C, refer to the record kept by parliamentary drafters who worked on the statute? Is it D, give the words of the statute their ordinary and grammatical meaning? Or is it E, make use of an academic textbook as an external aid to interpretation? So this question is one on statutory interpretation. And what you have in your potential answers here is a list of the various approaches or methodologies that the courts can employ in interpreting what a statute is trying to say. Now, clearly, we're looking at the specific one, but all of these are established methodologies. So interpreting the statute that this does not result in an absurd outcome is a perfectly legitimate technique. Thinking about the intention of the parliamentary drafters and the processes of law reform and what the bill went through in the various stages in understanding what the statute was trying to achieve is also fine. If we're staying within the ordinary grammatical meaning of the statute, that can give a very simple solution on occasion. Now, if there is a real ambiguity or concern about the state of the law in this area, then the courts can use expert evidence, including academic commentary, to guide them in their decisions. However, the mischief rule means something specific. And for that, we only have one correct answer here, and that is option A. The judge will consider the defect in the common law which caused Parliament to pass the statute. In that context, we interpret the word mischief to mean problem. So what is the flaw? What is the fault? What is the problem that the courts are trying to fix, that the Parliament, that the legislator was trying to fix by including that section? And very often we have statutory sections that are meant to correct either pathways that the common law took that they're not considered appropriate anymore, or to deal issues of ambiguity that have plagued the courts for a very long time. So this is like one of the key motivators behind law reform, and a lot of the work of the Law Commission goes in that direction, in making sure that problematic understandings or problematic interpretations of the law are fixed through statutory involvement. So there we go. I just finished a long and amazing lecture on the English legal system. So it took me forever to put this together, because normally I kind of put new lectures for you guys on the YouTube channel with a degree of regularity, so we have like fresh content for the community. But that one took me weeks and weeks and weeks. But I've ended up with a really nice piece. So this is the latest one that's been published. It's available for paying channel members to view immediately, and it's on the queue for publication. It's going to come up for the whole community at some point and towards the end of December. So this is like an hour-long lecture that explains the key fundamental points about the English legal system, constitutional law, human rights, the link between the various devolved assemblies and different powers to make decisions between England and Wales and all of that stuff. So I'm really happy with it, and I think it starts off also with a very funny way that has got me carrying around a fish. Like a big live salmon. So if you guys are interested in kind of funky visuals as well, then that lecture is definitely good for you. Now, how do you feel about all this, by the way? Do you do the videos that have got fancy visuals, do they attract you? Are you likely to watch those more than the others? I've been experimenting with improving the quality of the video visuals that I put to kind of accompany my lectures, and I'm getting some good results out of the latest set that I've done. So the videos that I've been publishing over the last couple of months are doing a lot better. So maybe it is that people find these topics attractive, or it could be that the kind of more elaborate visuals that are going in there are nicer. So if you like the visuals and you would like me to invest more time in kind of putting fish and kind of animals and stuff in the lectures, give me the thumbs up. If you're watching this on the replay, also give me the thumbs up. Then I will take positive messages through thumbs up and comments as a license to continue to make videos with me carrying stuff around. Yes, that's what we're gonna do. I do have another video where I'm carrying around. What is that I'm carrying around? I'm carrying around a peacock. Did you see that one? That I'm walking around chasing a peacock. Yes. So that's also, I think it's the tort video. One of the more recent videos that are queued to publish in the next few weeks. All right, so this question 49 from the SRA's set was the question that we had on statutory interpretation and the mischief rule, which means the problem that Parliament is aiming to solve. Let's see what question 50 is about. Oops. All right. Question 50. And I just had an idea. I was thinking of bringing one of my digital avatars to participate in our live sessions. And I just realized that in the same way that I'm sharing the PowerPoint, I could share the screen where the avatar is on and attempt to have a discussion with the avatar that way. So I'll workshop this a bit and see if I can do it. You never know what's going to happen. Maybe we're going to come up with a format that actually works and you guys like to watch. Question 50. A woman is driving her car along a road when she sees the warning light indicating low oil engine. Low engine oil. Yeah. The woman stops the car at the side of the road and turns on the car's hazard warning lights. A passing motorist sees the woman and stops to offer assistance. The motorist has some spare engine oil, and the woman agrees that he should pour some of this into her car's engine. The oil warning light turns off. The woman assumes everything's fine. She drives off, but about 20 minutes after, her engine seizes up, causing considerable damage to the car. A garage carries out repairs to the car. She is told that the motorist had used the wrong type of engine oil, and this has caused engine damage. The woman wishes to bring a claim in negligence against the motorist. She seeks advice from a solicitor who believes that there are no similar precedents or comparable cases by which to establish whether the motorist owes the woman a duty of care. The solicitor's legal advice about what the court will consider is based on this belief. Some solicitor. Yeah, don't be that solicitor. What legal advice will the solicitor provide about what the court will consider when deciding whether the motorist owes a duty of care in negligence to the woman? It's kind of peculiar. That's a peculiar question, don't you think? It's like, why does it need to tell us that the solicitor basically makes a mistake at the beginning? I'm not so sure. So the question is, yes. The question is, what legal advice will the solicitor provide about what the court will consider when deciding whether the motorist owes a duty of care in negligence to the woman? Is it A, solely whether the motorist could reasonably foresee that harm would be caused to the woman's property? B, solely whether the motorist had the relationship of proximity with the woman and whether it was fair, just, and reasonable to impose a duty on him? D, C. Did I say C? C. Solely whether the motorist could reasonably foresee that harm would be caused to the woman's property and whether he has a relationship of proximity with her. D. Whether the motorist could reasonably foresee that harm would be caused to the woman's property, whether he has a relationship of proximity with her, and whether it is fair, just, and reasonable to impose a duty on him. E, and that's the final one, whether it is fair, just, and reasonable to impose a duty on the motorist to the woman. What? Whether it is fair, just, and reasonable to impose a duty on the motorist to the woman. Right, fair to the woman to impose a duty. I think whoever drafted this must be having a bad day, yeah? Because there are a few things. I know that this is the SRA sample, but I mean, come on. There are many things wrong with this question. Now, we are in the domain of tort law. And the question is asking about a duty of care. There are two grand categories that we need to keep in mind. Is the situations where a duty of care is imposed for a particular circumstance that is pre-existing, pre-identified. This is normally like statutory duties of care. For instance, the duty that every motorist has to other users of the road. So this is not an ad hoc duty. This is a statutory duty implied by law to all the motorists. But we also have situations where a duty of care can arise in bespoke ad hoc circumstances when there is no pre-existing duty, like when you're driving a vehicle. A pre-existing duty exists if you're the occupier of premises, perhaps, for people not to be injured while they're in your space that you control. If somebody, however, is kind of minding their own business in a public space and they're close to you, and for some reason, due to their negligence, they cause you harm, there is no pre-existing category that can kind of hoover this up. In that case, we're talking about an investigation of whether a duty of care exists in novel circumstances. The key case that contains the tools to interpret this is the Caparo case. This is Caparo Industries versus Dickman. It's a case from 1990. You know, I like that because, you know, I used to be a student in the 90s. So I'm very partial to cases from the 90s. So the Caparo test requires certain things. This is what the question is about. It's about to test whether you know about the requirements in the Caparo test. And all the questions here, A, B, C, and E, are components of that test. The only potential answer that contains all the components of the test together is D, where it's got them all together. So we need proximity. We need harm to be caused to the woman coming out of the action of the person. And it needs to be fair, just, and reasonable in the circumstances to impose the duty. Okay, so there has to be a relationship of close proximity. Harm needs to have been caused by their actions. it needs to be fair to assume the duty in the circumstances. We need to have all the causal links that tie everything together and so on. So this is a terrible question because if you know about the Caparo test for establishing a duty of care in ad hoc circumstances, it is none of these things in isolation. It's all of them together. And the fact that A, B, C, and D just say solely, and only one has got all of them together, it's a kind of dead giveaway that the correct answer is D, isn't it? There we go. This is my hope for you. I wish that when you take SQE1, all the questions are going to be as easy as this one. Perhaps the difficulty here comes from the fact that the scenario is so long. So it's like a very chunky scenario, which is going to waste your time to read it, because remember, you've got less than 2 minutes per question. Yeah, less than 2 minutes. So by the time you kind of work your way through all of this, you probably spend more time and you've got very little time available to think, but there we go. Otherwise, in terms of content, I think the question is both poorly written and the answers are probably fairly obvious, right? So the correct one here is going to be D. Thank you, SRA, for giving us an easy question in the form of question number 50. Okay. So let's see. 47 we had done yesterday before we got interrupted. 48 we started doing and we finished off today. We've moved on to 49, 50, and now we are going on to question 51. Let me just try and scroll to that one. Now, if you guys are dying to get more questions, so you just love SQE style MCQs and you cannot have enough of them because you've been listening to me, and now every time you pick up a cup of coffee, you're thinking, coffee? I gotta do an MCQ, because Dr. Yannis said every time I stop for a coffee break, I should be doing MCQs in order to prepare for the SQE. So if this has been kind of drilled into your head and you're dying to find more MCQs, where are you going to get more MCQs? I've got a solution for you guys, and you don't have to put any effort in this at all. What you need to do, email news, let me spell this, it's not going to help, newsletter at glintis.co.uk. Email this with the word subscribe in the subject matter, and I'm going to add you to my mailing list. Every Monday, I'm going to send you a fresh SQE1 style MCQ for you to try at home. What I'm going to do as well, I'm going to give you the answer to the previous week's question with a full explanation as to why the correct answer is correct and why the wrong answer is wrong. I'm also going to give you reading material or a video to watch that helps embed your understanding of the substantive area of the law that the question is about. And I'm going to give you a bunch of discount codes, so you can get discounts if you go and buy books from Revise SQE, if you want to take advantage of the MCQ database and the law tutor from Law Drills, other things that I've negotiated deals from time to time that give you nice discount codes. So you're going to get the MCQs that you're after. You're going to get things to study to embed your understanding. You're going to get discount codes to save you guys money. And you're going to get all of this on the newsletter every Monday without fail. And all of it is free. Yeah. Isn't that great? So then when you stop, you're going to have to wait to receive the newsletter. I send it every Monday, but I'd say it at random points. Okay, I don't have a specific time for it to come out because I'm sending it manually. So you're gonna have to wait all Monday, coffee in hand, and the moment the newsletter hits, then you're gonna be like, "Booyah! Yannis sent the newsletter. Let's have a cup of coffee and attempt the MCQ." That's what you're gonna do. Okay, that's what your life is gonna be from now on. It's gonna be coffee breaks and MCQs again and again and again and again, till you hit your SQE1 sitting and pass, and then put all this nightmare behind you. Yeah. Are you guys trying towards the January sitting of SQE? If you're from the people watching us live, it would be awesome if you let me know in the chat. If not, feel free to put it in the comments, and I can reply to you afterwards. So if we have you here preparing for January SQE in 2026, then we're getting close. So you're gonna ramp up your prep, get your hands onto as many MCQs as you can. If you are preparing for July, we can take it easy, but we still got, you still have to put the prep in, but you got a little bit more time to go. Also, if you start your preparation now, probably not for January because it's too short, but if you're starting your preparation now, looking forward to July, go to my website. And this actually comes with a newsletter as well. I've created an adaptive study planner. So this is like a little app that works on my website. You put your preparation starting date. You select whether you want to sit FLK1, FLK2, or both. You select your target examination. Is it going to be July or is it going to be January? And the app has the syllabus, the FLK, pre-programmed inside, as long as with something that I made myself, like a weighting of how difficult the subjects are. So it's going to then spread out the totality of the FLK across the weeks that you've got available, and it's going to tell you what you should be studying every week to give you enough time to cover the totality of the FLK from the point that you start your prep up until the point that you have to sit the exam. It's going to feed in some rest weeks and some revision weeks and stuff like that in there. And it spreads out the FLK, knowing already what are the difficult subjects that you need to spend some more time on. So when you get the newsletter on Monday, go to the app and give it a shot and let me know what you think about it. I'm still testing it out to see what people think. But I think it's going to be a useful contribution, especially if you're self-studying. So you need to organize all these stuff and make a calendar for yourselves and so on. I think the app can be very helpful. If you're with a prep school already, then the prep school already has probably given you a syllabus that you need to go through and has given you like a calendar and a schedule to help you do it. So in any event, go through the app. If you're a self-studier, it's going to help immensely. If you're already with a prep school, it's probably going to reinforce what you're doing anyway. Okay, question 51. Yeah. All right. A limited company supplies bike stands at a cost of £15,000, including VAT, to a sole trader who sells electric bikes. The defendant is VAT registered. The defendant fails to pay the amount due. The claimant instructs a solicitor who obtains a money judgment in the county court for the full sum plus interest. The defendant does not pay the judgment debt within 14 days as ordered by the court. The claimant accurately informs the solicitor that the defendant rents a very expensive apartment. Her business is doing well, and she also leases an industrial unit when she sells and stores all of her stock. She also pays money monthly into a bank account in the joint names of her and her spouse, which has a current balance of £30,000. Okay, all of this is like quite a lot of fluff, right? And we're getting to a kind of unexpected request. What is the best method of enforcing the judgment to recover some or all of the judgment debt? Aha. Is it a warrant of control? Is it an attachment of earnings order? Is it a charging order of the apartment? Is it a third-party debt order? Or is it a writ of control? Now, to be honest with you guys, I wouldn't know how to answer this question. I've been teaching this stuff for 20 years, and money judgments and kind of that part of civil procedure process is not something that I have come across. All right. So in order for you to be able to effectively answer this, you do need to have a level of understanding and engagement with that part of court procedure that has to do with enforcement and who to send to pick up to try and retrieve the assets from somebody who has an order against them and is in default. Now, there's only one correct answer here, which you would figure out if you look this up. The correct answer is E, a writ of control. What is that? That is a high court document. This allows an enforcement officer to seize and sell the debtor's assets. So why is this a preferred option than some of the others? Because this gives greater leeway to the enforcement officer to select from available assets in order to satisfy this debt, as opposed to taking possession of any particular asset within those. So I didn't know about this. You didn't know about this. Probably nobody knows about this unless you're actually working for a debt collector, or whether you are in the unfortunate position of having to prepare civil and criminal procedure in the context of the SQE. But yeah, so that I find this particular question to be difficult, and also having it popping up in the set for FLK1 is a little bit unusual. So today's set, or actually this week's set, if we're starting from what we did last week, from question 47 all the way to question 51 from the SRA's sample, I think is a very mixed bag. I mean, there are some that seem to be dead easy, and there are some that seem to be in the really niche areas of the law that don't seem to come up very often. Now, having said that, there are so many questions. There are 180 questions that they can put in the SQE if you count, and if you count FLK1, FLK2, there's plenty. So they do have the space to actually ask you questions about absolutely everything. Do you need to have the correct answer about absolutely everything? No, you don't, because if you're scoring, say, 60%, then you're probably in a good space to pass overall, considering how horrible the results are getting. So you don't need to get the correct answer for absolutely everything, but obviously the higher you score, the more correct answers you have, the better it gets. Question 52 from the SRA's MCQ sample for SQE1 FLK1. A solicitor working in a large firm becomes aware that the client whom she's representing in the purchase of a property is involved in money laundering. She makes a disclosure to the nominated officer at the firm. The nominated officer considers the information provided with the disclosure and agrees that there's evidence of money laundering. Question: to whom must the Let me say this again. To whom must the nominated officer report any evidence of money laundering? Is it A, the National Crime Agency? Is it B, the Law Society? Is it C, the Solicitors Regulation Authority? Is it D, the Financial Conduct Authority? Or is it E, the solicitor acting for the seller of the property? Okay, what do you guys think? From the people that we've got watching us live, put your suggestion in the chat if you want to do this. If you are watching it on the replay, also feel free to kind of offer your opinions using the comments area underneath the video. All right. The correct answer here is, what is it? A. Yes, National Crime Agency. Now, why is that? So the question, first of all, is in the area that we call ethics and regulation of solicitors. It comes under FLK Legal Services. Now, on that topic, I'm in the process of making an entirely new video that is going to cover the totality of the SRA's specification for the FLK in legal services. So keep an eye out for this. I'm working on it at the moment. It should be available in the next couple of weeks, or perhaps a bit earlier, where I'm taking you through the entire specification, including things like money laundering, financial disclosure, and all the rest of it. So this is the FLK that positioned this. Now, in order for us to figure out what's going on here, we need to have a little bit of a think as to who might be what might be a relevant answer, right? Now, there are a couple here that jump out as being wrong right off the bat. So E, that says the solicitor acting for the seller of the property, that's not a good idea, right? Because it's their own client. So they've got a duty to their own client, and they also have a duty of confidentiality. And it's all covered by privilege and all of that stuff if it leads to other issues. Therefore, telling the counterparty on the other side of the transaction is definitely a bad idea. So E is like clearly wrong. Should they tell the Law Society? No, because the Law Society is no longer the regulator. Oh, Amazon delivery, of course. Give me a sec. See, I told you. So you spend the whole day, sitting around, yeah, and the Amazon delivery arrives right at the last second. Usually after the stream has already started. So sorry for the interruption, but there we go. And we're advertising these guys for free. Yes, so they owe me one for that one. Okay, now I was saying that the Law Society is no longer the regulator. Okay, because the solicitors are not regulated by the Law Society, they're regulated by the Solicitors Regulation Authority. So the Law Society has some involvement in the profession, is the sort of industry representative body. It does quite a lot of things, is involved in discussions and processes in relation to law reform, but it is certainly not the regulatory body that one could report somebody. So B and E are definitely not appropriate at all. Now, what do we have left? We have the National Crime Agency, the SRA, and the Financial Conduct Authority. The Financial Conduct Authority is the regulator for financial firms, banks, financial institutions, that sort of thing. But why would the solicitor report to the Financial Conduct Authority if they come across something in the context of their work as solicitors? If they were offering financial advice, then they would be regulated by the FCA, depending on what it is that they're actually doing. But if they're offering legal advice and they come across something that is a regulatory function, like checking for money laundering, why would they go to the FCA? So even if you don't know much about this area of the law, and if you haven't kind of watched relevant videos and you're not familiar with the solicitor's obligations and regulatory environment, I think you could discard B, D, and E with general knowledge. So your key choice here is going to be between A and C. Should it be the National Crime Agency or should it be the Solicitors Regulation Authority? The answer is contained in the Proceeds of Crime Act of 2002, going by the acronym of POCA because it makes it sound cute. So the Proceeds of Crime Act contains an obligation for solicitors to fill in what is called Suspicious Activity Report, an SAR. And this is sent to the National Crime Agency according to this legislation. Now, I wouldn't expect you to know this unless you've actually gone through this area of the law, but this is the relevant reference. So the relevant statutory reference is POCA. The report is called the Suspicious Activity Report, and the regulator that this goes to is the National Crime Agency. This is how money laundering is reported by solicitors who come across this. Now, this is, of course, one of their obligations. If you've been involved in a property transaction for buying a real property, or if you have studied property law, conveyancing, and any of that stuff, you're going to see that there's a series of really significant obligations on solicitors when handling client funds and being able, giving the clients the opportunity to prove and being able to prove where these funds are coming from. So there's quite a lot of paperwork that needs to be filled in order to verify the origins of funds, precisely to satisfy types of legislation like this one that are designed to combat money laundering. That's why you cannot turn up with a plastic bag full of banknotes and attempt to buy a house. I mean, This is everybody's favorite way of doing it in Greece, but this is not how it happens in the UK. Or in any event, if you realize that this is an option that's been given to you, then somebody is doing something dodgy, and you should report them to the SRA for not doing their job as solicitors properly before you even get into the money laundering stuff. Okay, so this is an ethics and regulation question. The key legal reference is the Process of Crime Act, and the correct answer is answer A, the National Crime Agency. Okie dokie. Right. Now, shall we move on? Okay, let's move on. There we go. What is going to be our next question? Next question is question 53. Okay, what do we have in question 53? A man visits a solicitor. And, you know, don't judge me on the gender specific stuff here, okay? This is how the SRA structures its questions. A man, a woman, a company, right? When we tried to kind of give names and stuff to liven this up a bit, they said no. So their standard for structuring these questions is this kind of really gendered and generic and kind of depersonalized fashion, but, you know, whatever. A man visits a solicitor. The man informs the solicitor that he's the director of a company in which he's also employed. He explains that the company is wholly owned by a US company and that the other directors of the company are officers of the parent and reside in the USA. The man resides in England. The man explains that the parent has requested that the company purchases a particular property in London, from which the company will operate to expand its existing business. The man further explains that the board of directors of the company has met to consider the parent's request and has resolved to proceed with the purchase of the property as they have determined they have determined that such a purchase would promote the success of the company. That's what they wanted. The solicitor is asked to advise on the purchase of the property. Which of the following statements best explains who is the solicitor's client? Okay, so we need to work out who the client is. Is it A, the parent company, because the company is wholly owned by it? Is it B, the man, because he's the director of the company who is resident in England? Is it C, the company, because it is the company that will be purchasing the property? Is it D, the parent, because the parent requested that the company purchases the property? Or is it the board, as it has resolved to proceed with the purchase of the company? Okay, what do we think is the right answer here? This is not a property law question. I know that it talks a lot about the purchase of property, but you shouldn't be guided down a path that makes you think that this is somehow a property law question. This is a company law question, right? This is very much FLK business law, which deals with the basics of corporate organization, separate corporate personality, and all the rest of it. I think the long scenario here is meant to misdirect you. Now, with this in mind, we need to think about the background of separate corporate personality and who is the entity with the legal personality that is behind this transaction. If we think of it in those terms, then the answer should be obvious. The correct answer should be C, the company, because it is the company that is purchasing the property. So the solicitor is asked to advise on the purchase of this property. He's asked to advise by the director of the company. The director of the company is not operating in his personal capacity. Directors are by law representatives of the company, so they're considered the agents of the company. So any request that comes through the directors is a request that comes from the company. The purchase is made on behalf of the company. Therefore, nobody else is involved in the client-solicitor relationships other than the company. A is wrong. The parent is the shareholder. You don't deal directly with the shareholders in a corporate environment, you deal with the company. The man, no, because as we said, the man is a director and he's not acting in his personal capacity, he's acting as an agent of the company. D that says the parent is wrong. Again, the parent is the shareholder. E that says the board is also wrong because the board of directors is the decision-making body of the company, but it's not the one with the personality and not the one that engages in those transactions. The company itself is. So the answer here is C, the company. The company will be the solicitor's client. It is because the company is purchasing the property. Now, we can take the opportunity here to clarify a couple of things about the way these questions are set. The multiple choice questions that you've got for SQE1 are always in this scenario. You're going to get a fairly chunky question, an expansive scenario, and then a set of 5 possible answers. Your job is to navigate this scenario and to select one of the options that comes the closest to asking the specific question that you are asked to address. Now, multiple choice questions and possible answers are not perfect. It is possible that all of them look somehow wrong. It's also possible that more than one looks a little bit right. So what you need to do is that you need to shift your mindset. You are not answering, say, questions in math where there can be only one correct answer. You're answering questions that are a little bit more nuanced. For that reason, because the questions are not perfect, because the answers are not a perfect match, you're looking for the one that matches the best. So do not look for the one complete and absolute correct answer. Look for one of the possible answers that comes the closest to answering the question. Do not expect perfection, okay? So it is the closest fit. Now, the way they normally structure these, you're going to have one that is the closest fit. You're going to have another one or two that seem to be at least superficially correct, but there's going to be something wrong with them. Either they misunderstand or misstate the facts or the law somehow. And then you're going to have a couple more out of the 5 that seem to be like way off. Like they seem to be like really distant from what's going on. I think here, if you're familiar with corporate organization and its consequences, it should be fairly easy to pick up the correct answer as being C. I think the problem comes more from the length of the question. And because it talks a lot of property law and the property transaction is going to put you in a mind frame that this is somehow a land law or property law question. And it might take a while for you to kind of shift back to the corporate that it's actually the core of the question. Remember that the time constraints are the most significant problem here. You've only got less than 2 minutes to spend per question. So to be able to navigate effectively a lengthy scenario and a lengthy set of potential answers, it's going to be tricky. Okay, so be prepared to make a decision in a hurry. Be prepared to make a decision amongst possible options that seem to match more or less, right? Do not expect really short questions. Do not expect really short scenarios. Do not expect one highlight absolutely correct answer amongst a group that are completely wrong. Okay? So I'm trying to highlight this in every session that we're having together because it is so important. I think anticipating what the questions are like and anticipating what the task is framed to do is supremely important. These are not like the multiple choice tests that you've had at law school or you've had in other contexts or if you did some other training and so on. These are fundamentally different. Okay, so hopefully you guys are finding this useful, and we are gonna move on to our next question. Okay, which is going to be question 54. Just try and switch our slide. Oh, man. You guys are not going to like this. I know that you're not going to like this. You're not going to like this because it's got numbers on it. And if there's one thing that we know, lawyers do not like questions that have got numbers. Yeah. If you guys did better at math at school, you probably would not go into law to begin with. Am I right? Yeah. Okay. Now, question 54 from the SRA's set. A woman owned a pet shop which she ran as a sole trader. She decided to sell the pet shop and become a partner in a dog grooming salon, which has been operating for a number of years. When the woman joined the partnership, she took out a loan of £10,000 at an annual interest rate of 10% to purchase her partnership share. The loan is still outstanding in full. In the 24-25 tax year, let me see what it says, 24-25 tax year, the woman's share of the partnership profits was £38,000. It took longer than the woman anticipated to find a buyer for the pet shop, but she completed the sale on the 6th of April, making a profit of £10,000. In 2024-25, the personal allowance is £12,570, and the basic rate of income tax is 20%. The basic rate tax band is from 0 to £37,700. Awful maths-based question for you guys. What is the woman's liability for income tax in the 24-25 financial year? Whoa, yeah. Okay. Now, how do we feel about this? If you guys are you're feeling uncomfortable about questions that have got numbers on them, let me know in the chat or put your thoughts down in the comments if you're watching this on the replay. I would really like to assess the level of competence that people have got over kind of tax calculation questions. Maybe you guys are better than me, yeah? Maybe here the problem is me and not you guys. And it is a little worrying considering I'm actually doing my own taxes, but hey. So the question here is one of tax. It is one of tax liability. But pay attention to what the question's actually asking. What is the woman's liability for income tax? There are different types of taxes, okay? The question is not about total tax exposure. It is specifically about income tax liability. How are we going to work this out? We need to consider, first of all, the partnership income. This was £38,000. However, she has taken a loan, okay? The loan was a £10,000 loan and it had a 10% interest, meaning that she spent £1,000 servicing that loan. Interests on loans are tax deductible. They're considered to be an expense. So when we are trying to assess what is her income out of the partnership, we need to adjust her income to take account of these deductible expenses. So her taxable income from the partnership is not the totality of the 38,000 profit share. It is that minus the 1,000 that she has paid as interest on her loan. So her adjusted income from the partnership is £37,000. Now, do we need to worry about the income from the sale of the pet shop? No, we don't, because the question is asking you about income tax. The sale from the shop is going to be capital gains. Yeah? So does it belong in the 24-25 tax year? Yeah, it does, because it was down the 6th of April, and anything above the 5th of April belongs in the next financial tax year. But that ain't the problem. The problem is that income from the sale of the shop would be capital gains. Capital gains would not be income tax, and that has its own bands and it's calculated separately. Since the question is asking you about income tax and not total tax liability, you should not look at that one. Yeah? So what we have is the £37,000 as the adjusted income from the partnership, minus the personal allowance, which is 12,570. That leaves us with 24,430. That 24,000 and change is going to be taxed at 20%. if you run the calculation, you end up with a tax liability for income tax at 4,886, which is option A. Okay, that is it. There's no point. There's no point in considering why the other options are wrong. The other options are wrong because they're not 4,886. Okay. I think the key danger here is that people are going to go and assess total tax liability because they missed the part that says liability for income tax. So this is where we need to be super careful with this stuff, guys. It is small details in the wording of the question that can really throw you off and lead you down the wrong path. So you need to pay very close attention to the wording of the question, because something small that you might miss that's kind of buried in there might be taking you down a completely different pathway. If you missed the fact that says liability for income tax and you just read quickly liability for tax, you would have done the wrong calculation because you would have included the capital gains, and then you would have ended up with another amount, or worse, you would end up with an amount that doesn't match any of the options, and then you would have freaked out because you would think that you got your calculations wrong, and then you would lose time. This definitely looks like a question that you're going to spend more than 2 minutes on. Any question that you spend more time on comes at the detriment of all the other questions. Now, okay, fine, you're going to save some time because some questions are going to be fairly straightforward, or they're going to have small scenarios to support them, but it is really bad practice to be spending ages in one question hoping to make up the time later. Okay, that's why I don't like numbers questions, because unfortunately numbers questions force you to do calculations. Calculations take time. All of this risks you spending more than the 2 minutes that you should have allocated per question. Now, before we move on to our next question, I would like to say thank you to the Big City Podcast, which is one of our new paying members for the channel. Now, I would like to remind you guys that if you want to support this channel and my efforts here, you can become you can join the channel as paid subscribers. So for the ridiculously low price, inflation data came in today. So things are getting more expensive, but my service remains the same. So for £2.99, which is less than your average cup of coffee, you can support this channel and you're getting a set of significant perks, the main one of which is you get to see all the videos I have queued up straight away. All the videos that I make will eventually become available to watch for free to everybody. But if you're in a hurry, especially if you're preparing for the January 2026 sitting of SQE1 and you want to kind of front load your preparation, all the videos that I've got queued up, they're all instantly viewable to everybody who is a paid channel member. And also I do the occasional paid for live stream and so on. So I would like to thank the Big City Podcast for supporting my efforts, and all my other subscribers. We've got many now, which is awesome. And if we hit like much bigger numbers, then I can do more scheduled specialized streams for the members as opposed to the ad hoc ones that I do now. But do let me know, especially if you're a channel member. You've got access to our special Facebook group. We've also got a group on Reddit that you guys can join. So do let me know through these avenues what you would like. And then I've got the capacity to kind of add more things. So feedback is always fantastically welcome. So if you've got any ideas in general, feel free to put them in the comments underneath this video too, because I would love to know how you guys are getting on. But yes, once again, thank you so much to all our subscribers, and specifically our paying channel members that are supporting the channel. All right, so we have succeeded in navigating, hopefully not too painfully, the question on tax. Let's see what the next question is about. Question 55. So there we go. We are working our way through the SRA's SQE1 FLK1 sample questions. Yeah. Now, this one is about some shopping, which, with Black Friday coming up, is probably something that everybody is thinking about. A little tip here: before you go and buy something, do actually price check it properly, because a lot of that stuff claims to be on sale, but in fact, it is not. Now, question 55. A recruitment company wishes to buy a small kettle from a retail company for the use of its employees. When the office manager of the recruitment company first visits the retailer's premises, the kettle is not in stock. The retailer therefore orders one from the wholesalers, and the office manager later returns to the retailer to collect it. After being used just twice, the kettle stops working. It's very disappointing. You might imagine making a cup of tea with cold water is not a good idea. On the other hand, if you were making Greek coffee, you would need a kettle. So there we go. But anyhow, so the kettle doesn't work. What claim does the recruitment company have? Okay. Is it A, the kettle is not of satisfactory quality under the Consumer Rights Act of 2015? B, the kettle is not fit for particular purpose under the Consumer Rights Act? C, the kettle is not of satisfactory quality under the Sale of Goods Act? D, the kettle is not fit for particular purpose under the Supply of Goods Implied Terms Act 1973. Okay. E, the kettle is not of satisfactory quality under the Supply of Goods and Services Act 1982. Okay. I was kind of giggling there because I like the idea of a particular purpose. I mean, what's the purpose of the kettle to begin with? It's to boil water, right? Could you have a kettle that just boils water for tea? I bet you could. Maybe it's like a specific kind of temperature setting or something. Who knows? Are you guys, let me know in the chat or in the comments box, are you tea drinkers or are you coffee drinkers? Considering this is our Wednesday coffee break, maybe we're attracting more coffee drinkers than tea drinkers, but I will not hold it against you. All right. Now, the correct answer here is C. The kettle is not of satisfactory quality under the Sale of Goods Act 1979. Why is it not of satisfactory quality? Because it broke, okay? Now, fitness for purpose isn't the problem. I don't even know what to say, okay? I mean, the purpose of the kettle is to boil water. If it doesn't work, it doesn't work. So there is no specific purpose here. So we can discard B and D that talk about fitness for purpose, because this is not what the problem is. Our problem is satisfactory quality. Something that breaks 2 times after you've used it is not a great product. So A, C, and E talk about satisfactory quality. We can discard E right off the bat, because the Supply of Goods and Services Act is for goods that you get along with the provision of a service. For instance, if you get a new mobile phone contract and you get the device for free as part of the mobile phone pay monthly deal, then the goods would be classed as goods that come along with the service, because the main interest of the contract is the provision of the mobile service, and as an add-on you're getting the goods. Okay. Equally, if I have a contract for the maintenance of the house and they give me a smart meter as a gift when I do this contract, the services contract is what matters. The provision of those goods is ancillary to those services. This is not the situation here. The office manager did not go and get himself like some sort of service contract for which he got a kettle as a gift. He actually went there to buy a kettle. So anything that says fitness for purpose is wrong, because it's factually wrong. It addresses a different problem. E is wrong because the relevant statute is not the Supply of Goods and Services Act. Now, this is a contract law question, broadly defined. It has to do with the sale of goods. The the questions that we still have in the running are question A and question C. They say the same stuff, but they reference different statutes as the source of the implied term on satisfactory quality. Now, is it the Consumer Rights Act or is it the Sale of Goods Act? You need to think about the context in which this purchase is made. If this purchase is made to use in an office and it is bought by the office manager, and probably this is expensed from the company. This isn't something that has a dual use, that the guy keeps the kettle at home and occasionally brings his colleagues some coffee. This is something that is meant to remain in office premises. It is to be used by the office staff, and it has been purchased with this business in mind. Therefore, the purchaser here is acting in the course of business. This is not a consumer transaction. In order to have a consumer transaction, we need the seller to be acting in the course of business, but the person purchasing needs to have two attributes. The first one is that they need to buy for personal use, and secondly, they need to be a human individual. So if the guy went and bought this as the company and signed the invoice as the company, because the company is a corporate entity, the Consumer Rights Act does not apply. So then your only statutory reference would be the Sale of Goods Act. You cannot be a corporate entity and come under the jurisdiction of the Consumer Rights Act of 2015. Plenty of reasons for this that we shouldn't get into now, but this is like a good kind of cutoff point for you guys to know. If anybody's purchasing as a corporate, they cannot be a consumer, at least under this legislation. So this eliminates basically all the options apart from option C. The goods are not of satisfactory quality. Why should there be? Because Section 14 of the Sale of Goods Act 1979 implies this term into contracts of sale. If you would like more about this, I've got a variety of lectures that talk about contract law. Some talk specifically about protections in sales scenarios. I've got specific lectures on implied terms and how these come in, and also a distinction as to whether these implied terms are the ones that link up to consumer contracts or whether they're the ones that also link up to business contracts. And I explain how to make the distinction between a consumer and a business contract. So I've got a variety of videos that deal with those topics. If you're unfamiliar with this area of the law, I would advise that you have a look at those. It is a little bit, I don't think it's like conceptually a very difficult area of the law, but you just need to know some stuff. And once you get your head around it, then it's perfectly fine. Okay. So this was a sort of sale of goods, implied terms question, but the focus was on the identity of the purchaser, which is, well, I mean, that and the nature of the problem, which led us to eliminate the other possible options and to arrive in section C as the correct answer in this context. Now, I don't know. What do you guys think? Do you think this is a particularly difficult question? I don't think it's particularly difficult, and I think it is achievable in the context of like the time frame that you've got. But let me know if you found this particularly difficult. Now we're moving on to our next question, which is question 56. All right. Now, before I explain this one, just one thing. Do you guys love multiple choice questions? Yes. Are you the sort of person that thinks, oh, I wish I had multiple choice questions to do every day, and I cannot just have enough of Dr. Yannis here explaining this every Wednesday live. I want more of them. So, on that, a couple of things. First of all, you can watch all the previous live streams that I'm answering these questions, starting from number 1 and then going forward. I've also put together a video where I edited these presentations and I cut off all the chatty bits and I left in the bits where I'm just explaining the questions. So I made like a specific video that's like kind of queued to publish. It's actually publishing this Saturday, I think. where I'm going straight into the questions 1, 2, 3, 4, 5. So if you would like a video that takes you through entire sets of 30 questions at a time without kind of interruptions, me going to open the door for the, for Amazon, or kind of the cats jumping on the table, and it's kind of a more streamlined experience, then feel free to watch that. Otherwise, you can catch all the questions that we've dealt with together and then some, because I've got sets of live streams where I do MCQs from previous occasions. You can have a look at all of those. But if this is not enough and you guys are dying for more questions, I would invite you to email. There it is. So if you email newsletter@glintist.co.uk, I'm going to put you in my weekly SQE1 MCQ newsletter. What I do is that every Monday I send this email out. It's got a fresh, not the SRA sample, there's a fresh question written by me, fresh question every week. And also I'm giving you the question from the previous week with the full explanation like we do here, but the whole thing's written down. And in addition, you get some extra bits. You get discount codes for purchasing books and other services that I think might be useful for SQE candidates. You get some reading material or recommendations to watch videos to kind of go deeper into specific areas, and anything else I can think of, really. So this newsletter comes every Monday. It's completely free to everybody. So if you're after additional MCQs, or you're trying to kind of expand the stock of MCQs that you've got from your prep school or another provider, and you're looking for more and kind of different kind of styles of it, feel free to subscribe to the newsletter. I'd love to kind of have you guys join our community there. Right, so question 56, which is going to be our last question for this set. A government department has recently been created to tackle terrorist threats in the UK. The civil servants working with the new department are involved in the handling of secret material relevant to national security. They've been selected from existing civil service employers. The staff brought into the new department were existing members of one of the big civil service trade unions. 6 months into the new posts, after an escalation in industrial action, some civil service trade unions, the staff are told that they've been banned from being members of the union with immediate effect. No consultation has taken place either with the staff or the union. The union did not participate in the recent industrial action. Staff wish to bring a claim under the Human Rights Act of 1998. They're alleging that their Article 11 rights to freedom of assembly and association, as they exist in the European Convention on Human Rights, have been infringed. Okay? Which of the following statements represents the best advice to the staff about the protections offered by Article 11? Is it A, Article 11 rights are qualified rights whose exercise may be subject to restrictions which are imposed in the interests of national security? Is it B, Article 11 rights are limited rights whose exercise may be subject to restrictions which are imposed in the interests of social and economic well-being of the country? Is it C, these are rights that are absolute in the respect of the right of the individual to form and join trade unions for the protection of their own interests? Is it D, the rights are qualified and a consultation is a necessary condition for any restriction on the right to form and join trade unions to be deemed appropriate? Or is it finally E, Article 11 rights are limited rights and are not subject to restriction when exercised by the armed forces, the police, or the administration of the state? Okay. Now, what do we think about this one? So this is about constitutional and administrative law, specifically human rights. Human rights and constitutional law are part of FLK1. So then this is something that you need to know about. Quite a lot of material, a lot of questions that we've seen have to do with the European Convention of Human Rights and how those rights, as interpreted through the Human Rights Act of 1998, are actually present in English law. So this is an unavoidable part of the FLK that everybody should be familiar with. Now, having said that, would you know what the actual answer is? Probably not, unless you've spent some time going through the convention rights and figuring out the status that is given to those convention rights. Now, Article 11, as we said, is about freedom of assembly and association. But what type of right is it? Is it a right that is immovable, that exists always and in all circumstances? Is it a right that is qualified, or is it a right that is limited? The only way to answer this is to look at the wording of the actual Article 11, which says in paragraph 2 that this is a qualified right. Okay? So Article 11 is a qualified right. This means that restrictions can be prescribed by law if there is a legitimate aim and it is necessary in the kind of proper running of a democratic state. So qualified right means that through appropriate legal process for the right reasons, there can be restrictions. So, having said that, the correct answer is answer A, because answer A says qualified rights whose exercise may be subject to restrictions in the interests of national security. This is correct. Possible answer B is incorrect because it calls them limited rights. This is not the right designation. The correct designation is qualified rights. C says that Article 11 rights are absolute. No, they are not. D says that they're qualified, but it also says that consultation is a necessary condition for them to be deemed proportionate. Now, remember earlier when I told you that there are various answers that might look correct and they're kind of just slightly off the mark? This is one of those, okay? Because yes, whether there's been consultation will be part of the determination of whether it is proportionate or not, and it has to be proportionate. This is what 11.2 says, right? We need to have legitimate aims. It needs to be necessary. So there's an element of proportionality in making those determinations. However, D seems to imply that the lack of consultation would automatically render this disproportionate, which is not the case. Okay, this is overtly harsh in interpreting the legal criteria. So even though you might argue that D is close to being the correct answer, we've got one that does better. Article A, that says Article 11 is qualified and may be restricted, is actually a less objectionable answer than D. Okay? So A and D could probably work. A is a little bit better. Article E, that says Article 11 is limited, again, is wrong because it misqualifies the article. It's not limited, it is qualified. Okay? So you can discard here the ones that say absolute and the ones that say limited. What you're left with is A and D, and you have to make your decision between those depending on which one gets closer to the actual position in the law, because D overstates the requirement. It is not the correct one. We are left with A. Now, would you guys be happy in answering that question? To be honest with you, I wouldn't be, because it is very lengthy. So you've spent a great deal of time trying to navigate the text that has the scenario. The possible answers are they're repetitive, but they're also quite chunky. The issue with repetitive is that you might miss the detail. They all start Article 11 rights. You read the same thing 1, 2, 3, 4, 5 times, you're not paying attention anymore. But the key difference between them is whether they call the rights limited or qualified or absolute. Because it's repetitive and because it's long, it might cause you to just not pay attention. And as a result, it is very lengthy, it is very repetitive, you're doing it under a severe time constraint. This is not conducive to you having a clear mind to select the best possible answer. So I don't like question 56, not because the topic is inherently like, like abysmally difficult, probably not, but because the question is complex and the options are very close together. Question number 57. So if you're looking for the previous questions from 1 till 56, look at the previous live streams. They're all published. They're free, but they're all live. You can see them on the replay. Nags is digging up the door trying to get out. Yeah. Well, enough with the cuddles there, Nags, huh? Okay. Now, question 57. A claimant issues a claim for breach of contract against the defendant. The defendant fails to serve its defense within the time limit required, and the claimant enters judgment in default of a defense. The defendant applies to set aside the default judgment, and the application is heard in the county court before a district judge at a hearing center outside London. The district judge refuses to grant the application. The defendant is granted permission to appeal and appeals against the order made by the district judge. Who will hear the defendant's appeal? Oh man, hi, we've got somebody in the chat saying, hi, how are you doing? It's awesome that you're joining us live. Look, you know what? This is the kind of question that kind of goes, like a lecturer, a student, and a panda walk into a bar. What color is the kettle? So unless you are familiar with this area of the law, and the topic here is civil procedure, oh man, you're gonna have difficulty working out what the answer might be here. In order to be able to understand this, you need to have an appreciation of Civil Procedure Rules Part 52 that discusses appeals and the designation of judges and orders to that effect. Now, clearly, I don't know if this is your strong suit, but civil procedure rules tend not to be anybody's strong suit, to be honest with you. Shall we venture a guess? We've got some people watching us live, so if you're minded to do this, let me know which one you think might be the correct answer. So the question is, who will hear the defendant's appeal? Our options are A, High Court judge in the High Court, B, Circuit judge in the County Court, C, Justices of Appeal in the Court of Appeal, D, Master in the County Court, E, District Judge in the High Court. Okay. Now, I don't want to stress you out, but ChatGPT got this correct first time around. Yeah. So the correct answer, ladies and gentlemen, is B. It is the appeal is going to go to a circuit judge in the county court. So it is going one level up in the same court that was originally hearing the case. Now, why is that? That is because of, as I said, CPR Part 52. If you look at the information on appeals, you're going to get your answer. The other ones are wrong, some of them for slight reasons, some of them for big-time reasons. Did you wonder why it says that the hearing takes place in a center outside London? This isn't just there for fluff, hardly ever, okay? The way these MCQs are structured, every piece of information there is relevant to something. So when it says it's outside London, you should get to think, does this have any consequences on the process? In fact, it does. If this was in the Royal Courts of Justice in London, then he would go to a High Court judge in the High Court in London. But that is not the case. That's why option A, that is based on location, is incorrect, because this took place outside of London. As we said, the correct option is B, higher level judge in the same court. What about C? It said Justice of Appeals in the Court of Appeal. No, this is wrong, because this is too high. So this is a further escalation step in appeals, which would be not appropriate for this type of problem. Would it go to a master in the county court? No, because there is no master in the county court. Would it go to a district judge in the high court? No, because there is no district judge in the high court. If you're despairing, so am I, because my God, I've written like an entire textbook on civil procedure, but even this stuff is a little bit niche for me. So hopefully you're not going to get a question on this, or if you do get a question on this, it's going to be a question that you can get wrong, assuming that you get all the rest of them right. So to recap, the correct answer to question 57 is question B, is answer B, circuit judge in the county court. Okay, let me close that door because the knights opened the door. There we go. Let's try and keep this closed. That's the problem with the cats. They're either sitting on you or walking in front of your screen or walking on top of your keyboard or opening and closing the doors. Okay, are we ready for the next question? Okay, let's see if we got something more pleasant coming up. Okay, it appears to be a tort question. I mean, I don't know. Are you guys fans of personal injury? Everybody's a fan of personal injury. Just remember, if you're qualified in a different jurisdiction, compensation for personal injury in England and Wales tends to be a little bit tight. So this is not like an American movie where everybody, when somebody has a tumble at the car park of a supermarket and then sues them for millions. It doesn't happen here. I'm having a Greek coffee today, by the way. I would recommend it to everybody that is watching us from the Middle East or of Middle Eastern origin. For everybody else, it is a bit of an acquired taste. All right, now, question 58. A woman owns premises from which she runs her business of providing spa facilities and beauty treatments to the public. A customer was injured while using one of the showers in the spa when several tiles fell off the shower wall onto her feet. The shower had been recently refurbished by independent contractors specializing in installing commercial spa facilities. They had been recommended by the woman's experienced surveyor who inspected and approved the completed works. The tiles fell off the wall because the independent contractors used inadequate tile adhesive to fix the tiles to the wall. Which of the following best describes the woman's potential liability under the Occupiers Liability Act of 1957? Is it A, she is not liable because she reasonably engaged competent contractors and had the work checked afterwards? B, she is not liable because the independent contractors had control of the premises when the negligent work was carried out? C, she is liable because the customer was a visitor to the premises. Okay. D, she is liable because the woman and the independent contractors are both occupiers. E, she is liable because the tiles are a danger on the premises. That question is a little too close to my own personal experience because I was sticking some tiles the other day in the bathroom that had fallen off, and because, as the question suggests, I did not use adequate glue, they fell on me when I turned to leave the room. So, but in that case, since I was responsible for the damage inside my own house, I wouldn't have anybody to sue. So it was all entirely my fault, but as you can see, I have survived. Okay, now, this is obviously tort. I've got nice, I find them nice. I've got nice lectures on the law of tort. I've got also a new series that is publishing at the moment. I have published this as a YouTube course. Now, this is a new feature that YouTube gives us, that you can put all the relevant videos in a kind of sequential way if it covers an entire topic and people can go through them. It tracks your performance through them, so it can tell you how much you've done and how close you are to completion. And once you've completed, it also gives you a certificate, which is really cool. So my new series is videos on the topics of FLK1 and FLK2 that are tailored precisely to the SRA specification. Because what I noticed is I've got a lot of videos, and I've already got videos on the channel that cover the totality of the FLK. However, I realized that it might be a little bit difficult for you guys to find the information that you need to read that is specifically tailored to the requirements of SQE1 against the various videos that I've published. And the same thing happens with textbooks and all of that stuff. So I thought I will make new videos that are tailored precisely to the SRA specification. So I went to the SRA website, I got the specification and the explanation that you get on the breakdown if you look at the content of the FLK per subject, and then I used that specification as the table of contents for my videos. So when you're watching these new videos in this new series, you're getting topic by topic precisely the headings that the SRA is asking you to learn in relation to that part of the FLK. And I think this makes it very easy for you guys to trace how you're working through the material as you're preparing. And probably eases up a little bit of the anxiety as to whether you're reading the correct stuff or not. So watching those videos together with a text that also follows that pattern, that is a text that is specifically tailored to the SQE, I think it gives you the best opportunity to prepare in a kind of efficient way. Okay, so we've got a suggestion in the chat as to what might be the correct answer here. So hopefully this is in relation to this one. So there's a suggestion that the correct answer might be C. Okay. Okay, let's think about this, okay? In the law of tort, and look at the new lecture that I've got in that new series, right? In the law of tort, the primary obligation comes from the duty of care. We can have a duty of care that arises in circumstances because of a relationship of proximity that has the potential to cause harm. If you're looking for details on this, look at the Caparo versus Dickman test, okay? That applies to general situations. But also, we've got specific situations where the law implies a duty of care. One of those specific situations is the duty that the occupier has over uses of their premises. This has statutory basis. This is given to you already by the question, because the question directly references the Occupiers Liability Act of 1957. So remember two things that are crucial to answering this question. We need to be sure that there's a duty of care imposed on the woman who owns the premises, which it is due to the act, but also we need to be mindful that that duty needs to be breached. Okay, so this isn't like a kind of strict liability situation where you have a duty and if something happens, you're automatically responsible. We need to establish the duty. Here it's established by statute, and then we need to establish a violation that actually causes the harm that the victim is complaining about. So with that in mind, let's have a look at the possible answers. A says she's not liable because she reasonably engaged competent contractors and had the work checked afterwards. What this suggests is that, yes, there is a duty of care, but the duty of care has not been breached because the woman was not negligent. Okay, keep that in mind. The second suggestion is that she's not liable because the independent contractors had control of the premises. No, that is wrong. That is wrong as a point of law, because the Occupiers Liability Act places the obligation on the occupier of the premises, not on any contractors or workers that might be in it. So B is wrong. C, there was a suggestion in the chat, says she's liable because the customer was a visitor to the premises. That, unfortunately, is wrong. And the reason is that it doesn't go the extra step of establishing that the duty that she has been breached. Yeah? So, yes, you have a duty as an occupier to visitors, but in order to generate an obligation to compensate, you need to breach that duty. And this is not happening in this case. D says she's liable because the woman and the independent contractors are both occupiers. No, they're not. Okay, so this is wrong on the facts. The contractors are not occupiers. E says she's liable because the tiles are in danger on the premises. Well, they might be they were dangerous, but we still need to figure out who has the duty and then whether that duty has been breached. Sometimes you've got accidents that are nobody's fault. Now, Having all that in mind, that we need to establish where the duty is, but if breaching that duty implies negligence, we need to check whether the occupier has been negligent. She has not been negligent because she got an independent contractor who's a specialist in installing these facilities, and then she had this checked by her surveyor, and everybody cleared it as being correct, meaning that she took all reasonable steps in ensuring that the facilities were safe. So even though there is a duty, she has not breached that duty because she was not negligent. Correct answer is A. Okay? Are we cool with this? If we're cool with this, give me like a thumbs up or some sort of kind of happy emoji in the chat that I know that you guys are agreeing with me. Actually, you're agreeing with me and with the SRA, right? Because this is the correct answer identified by the SRA. I'm not making this up. Alrighty. Okie. What else do we have? Okay. Now, tort is okay. I mean, I like tort. I mean, not like I like the commission of torts and the creation of victims, but seriously, if you have an undergraduate law degree from this jurisdiction, tort is probably much easier to swallow than some of the civil procedure and criminal procedure things that we actually never cover as part of the law degree. Okay? Now, are we ready for our next question? So let me just flip this to question 59. And by the way, I was mentioning earlier about our new series. This new series is initially available to channel members. One of them is notified on our chat here. Theo is one of our newest members. So thank you very much, Theo, for supporting the channel. What happens here is that you can be a paid member of the channel. This is going to cost you less than even a Greek coffee that tends to be cheaper than your average latte. Even though, did you guys see in the budget, if the budget's being announced today, apparently there's going to be a tax, an extra tax on sugary drinks, which means that our latte is going to go up. I know we should stick to a flat white or a Greek coffee. It's gonna get cheaper. But for less than the price of your average coffee, for $2.99 a month, you can be a paid member of the channel. And what you get all the videos that I've got queued up are available to you to view immediately. Okay? All of these videos will eventually become free for everybody, so the whole community can enjoy them. But they're on a publishing schedule, so the new videos come out every Saturday. Yeah. If you're in a hurry to see all of the videos that are queued up for the next month or two straight away, and to see these kind of curated series that I've got straight away, then you can join the channel and see those. And also support me in this process, for which I'm super grateful. In addition, I do additional things, like I do the occasional members only live stream, and I'm working on additional things that I can give the members. But I just wanted to mention this just in case you click on for the new series and you find that it's members only and it's not immediately clear to you what that is about. Okay, question 59. A paralegal has been employed for 18 months at a law firm. She appeared as a witness in a colleague's successful claim under the Equality Act. This was against the firm at an employment tribunal. The paralegal and the colleague continued to work for the firm after the claim concluded. A few months later, the firm pays a discretionary bonus to staff in their salary to thank them for their hard work that financial year. The paralegal and the colleague do not receive the bonus, unlike all other staff. They are the only employees to have been involved in the employment tribunal proceedings. The paralegal raises the matter with her line manager, but with no success. She is humiliated and upset as a result. The paralegal seeks advice on whether she can bring a claim under the Equalities Act for the failure to pay her the discretionary bonus. So, question for you guys. Is the firm likely to be in breach of its rules under the Act by not paying the paralegal this discretionary bonus? Okay. What are our options? Option A says no, as the bonus is at the firm's discretion only and not a contractual term. B, yes, there is a likely claim of direct discrimination. C, yes, there is a likely claim of victimization. D, yes, there is a likely claim of harassment. E, no, as the paralegal has not worked at the firm for 2 years. Alrighty, let's have a think about this. Now, you might be thinking, you look at this question, and you might be thinking, hang on a second here. I didn't know that employment law was part of the FLK. And you're going to be right. Employment law, broadly defined, is not part of the FLK. It is something that you would come across if you were doing an undergraduate law degree, possibly as an option, but it is not full-blown part of the FLK. Therefore, why do we have an employment law question? This is not an employment law question. This is a human rights related question, and that is part of the FLK. And that's why I've got specific videos on the channel already that are dealing with things that are kind of in the broader array of the FLK requirements, including in EU law, human rights law, Equalities Act, anti-discrimination. So all of that stuff, it comes under FLK legal services, and it is part of what you need to know, fortunately or unfortunately. So a broad understanding of employment law is good for life in general and for your personal stuff. Detailed understanding of employment law is not required, but an understanding of anti-discrimination legislation in the Equalities Act is required because it is part of the FLK. Now, incidentally, as we're going through this, the pattern of this question, the format that you see here, pretty much the others too, is the way these MCQs for SQE1 are normally structured, okay? So you're getting a fairly chunky scenario that takes like 6 to 8 lines, and then you got 5 possible answers. Your job is to navigate this scenario, read the possible answers, and select the one correct answer. You guys fan of the Lord of the Rings? I'm not, but I think there was isn't there a thing that there can only be one and they're all kind of running after the ring and all of that stuff? So in a similar vein, in the SQE, there can only be one correct answer. One important, the cat's meowing, you know what that means? It means he caught something and he's bringing me a gift. Hopefully you guys are not going to get to experience like a pigeon or something. Okay. The trick about these questions for SQE1 is that you're not looking at a perfect answer amongst a group of completely irrelevant wrong ones. You're trying to find an answer that best matches what the question's asking. It does not have to be a perfect match, but it has to be closer than all the rest of them. So keep this in your heads, but print this and stick it on the wall. You're not looking for the one perfect answer amongst completely wrong ones. You're looking at a set of possibilities, and your job is to pick the possibility that comes closest to answering the question. It may not be perfect. It could be that there are other possibilities that are looking somehow correct. So your job is to select the best, closest match. Now, the way that these 5 options are normally laid out, you're going to get one that comes the closest. You're going to get a couple that are kind of vaguely there, but kind of slightly wrong. There's something like weird about them. So out of the 3, there's one that comes really, really close, and they're the 2 that are like, could be, but, there's something iffy. And then you got 2 that are wrong, either on the facts or on the law. And you need to kind of make this decision. Now, what makes this so challenging? Because when you tell me if this happens to you, but take an opportunity to put an answer in the chat, or if you're watching this on the replay, let me know in the comments under the video. Do you get friends and family telling you, oh, you know, it's a multiple choice test. Why are you so bothered about it? It's gonna be fine. Multiple choice tests are easy. Does anybody get that? Because the candidates that I know and I'm dealing with, they get a lot of that, and it's demoralizing and annoying because it seems to kind of negate the effort that you're putting into this if people are kind of dismissive and they go, oh, it's just a multiple choice test. The reason why this is so difficult is not only because you've got a chunky scenario that you need to go through and that you've got 5 wordy, long, potentially relevant answers. It's because you got less than 2 minutes to select the correct one. That's why this is such a problem. And I've told them, well, not only me, but everybody has told them. I mean, a lot of people have told the SRA that this is not cool. And when they structured the SQE in this way, we did tell them we've got severe reservations as to whether this is the correct way to assess people. But that is why this is a problem. Chunky question, chunky answers, lots of material to get through, less than 2 minutes to make a decision and move on. Right. Okay. Back to the Equalities Act. So what is the problem here? The Equalities Act in section 27 says that if somebody does something, performs an action that is a protected act, and then they're subject to detriment because of this, so they're doing something they're entitled to do, and then they suffer detriment as opposed to this, that counts as a breach of the act. So what are the key things that we're looking for on the basis of section 27 of the Equalities Act of 2010? We're looking at somebody to do something they're entitled to do, and we're looking for them to suffer a detriment, a negative consequence on account of their lawful activity. So with this in mind, what would you pick as the correct answer? I don't know. I guess I get agitated by this. This question annoys me. Plus, it is so, the law firms are treating paralegals so unfairly. Everybody knows what a paralegal is, right? They're the people who work in a supportive capacity in a law firm, but they're not yet solicitors or they're not trainees, okay? Usually, they're people who are qualified overseas, and this is the first job that they find in a law firm in the UK, and usually they're going through some process of qualification themselves, right? A lot of paralegals are taking the SQE, and they might be amongst your community here. The reason why it's such a difficult job is because you're getting paid a fraction of what they're gonna pay their trainees. You're getting paid peanuts in relation to what they pay newly qualified, and you do all the work because you know what you're doing. So a paralegal normally is not some kid who just came out of uni and is trying to figure out what's going on. It's usually somebody who was quite senior in another jurisdiction and just came over and is trying to make a life here. So yeah, not an easy job. So if you are a paralegal, you've got my sympathy. Right, correct answer here, ladies and gentlemen. It is C. Yes. So she wants advice on whether she can bring a claim under the Equalities Act. Yes, she can. And the reason is that she's likely she can likely claim for victimization. Okay, so let's position this against the other possible answers. The first one says no, because the bonus is at the firm's discretion, not a contractual term. Terrific, but we don't care, okay? What we care about is the motive behind her exclusion from the bonus. We know that the bonus is discretionary, so A is a misdirection. B says this is a likely claim of direct discrimination. This isn't direct, because direct discrimination would mean that you're discriminated against because of one of the protected characteristics, like race, religion, you know, all that stuff. This is not direct discrimination. She's targeted because she helped her friend through the employment tribunal. D says, yes, this is a likely claim of harassment. No, because what we're looking for here is she's suffering detriment. This is not based on conduct. They're not being nasty to her directly. She's just suffering a detriment by being denied the bonus. Okay. E says No, as the paralegal has not worked for 2 years. We don't care, because for Section 27, there is no minimum term. Certain employment rights only kick in if you've been in employment for a certain period of time. Fair enough. Certain other entitlements also have time requirements to them, but not this one. So the correct answer here is C. She is likely a claim of victimization, and the firm is behaving in this way because they're upset with her because she supported somebody else in an employment tribunal. All around, very unpleasant. Okay. Okie dokie. So hopefully this hasn't happened to you guys, and it won't happen to anybody that you know. But if it does, then you know what it is, and you can come after your employer with a claim of victimization.